So rather than be Mr. Cheapo and not mention this until after I give my introduction and explain a little bit about the firm, I want you guys to understand if you are here as a director of an HOA and not a condo, you're in the wrong place. So you're not going to get HOA board certification credit taking this class. We do offer that class, but that's not what we're here for today. So hopefully everyone that is in the room right now, all roughly 100 of you, are directors of condos or managers that want this credit. So moving on, a little bit about the firm. K. Render Rembaum's been around since the 1990s. 24 attorneys, all practicing exclusively in the area of community association law. And when Kerstin says this is all she's done since 2010, I'm in the same boat. I've also been practicing 17 years, board certified specialist in this area of law, one of 8 board certified specialists in condominium law in the firm. We also have a construction law attorney board certified within the firm. So pretty much anything you might need as a community association, condo, co-op in particular, we've got you covered. If you are, as Courtney mentioned, if you're happy with your current counsel, good for you. I'm not trying to pull you away from them. But if you hear something you like today, if you want to reach out and discuss with me, with Kerstin, or with any of the attorneys in our South Florida offices, because there are 4 of them, feel free to reach out, or feel free to, you'll have the survey at the end of the class. Feel free to check that little box that says, please contact me. And you're welcome to specify whether you want Kerstin or me specifically to reach out. It'll generally be the person that's closest to your community. And I do want to very briefly, before I get started, clarify Courtney was so close, but so far. Winter Springs is where my office is located, and I manage that office. So I appreciate the effort. You got the Winter Park right. You'll get it eventually. It's okay. I know you guys are moving up to Jupiter. Hopefully you'll have an office in Winter Springs soon too, so that we can really partner locally.
Yes.
All right. I like it. All right. So moving into the materials, I'll go ahead and share the part of my screen that pertains to you guys. Give me one second. That should have worked. And now we can actually get started. All right, so you've got, and I know there was a question in the chat or the Q&A, will we get these slides? Yes, after the class is done, you'll get these slides, but the goal is for you guys to hopefully not be sitting there and, working as hard as you can to write notes while we're speaking. It's to listen to what we have to say, because there's a lot that I'm going to say today, and I know Kerstin operates the same way. We don't just read through what's in the slides. We're giving you practical guidance, giving you practical suggestions. But I do want to also point out, which Jeff usually does, and I don't know what happened, man. Maybe he didn't sleep today. But we want you to understand anything that we say during this presentation is
One
not...
coffee. I'm going to get another coffee now, but go ahead.
There you go. Anything we say during this presentation, although it may be legal in nature, is not legal advice. You need to rely on the guidance of your particular attorney. So you can bring to your attorney or to your board the fact that, oh, well, Alan and Kerstin, they're great attorneys, and they explain this during a board certification class. And that's great, but that's not legal guidance from your counsel. Even if I'm your attorney, or Kerstin is your attorney, or you work with our firm directly, you need to reach out to the individual attorney you're working with if you want something that you can rely on. Now, you can rely on what we're giving you to be accurate, but it's not legal advice. All right, moving into the actual materials. Well, okay, well, that's Kerstin. You just met her. That's me. You've met me. Now moving into the actual materials. Topic 1. We're talking about milestone inspections and structural integrity reserves. Kerstin was very kind. She let me take the first half, so she gave me all the boring stuff. So I'm going to do what I can to make this interesting, but understand, this is the driest topic in the entire seminar today. So I'm going to make the best effort, but I'm not making any promises. All right, milestone inspections. The first thing that you need to understand as a director who is subject to a milestone inspection requirement is, what the heck is it? This is literally just a physical inspection, not digging into the building or anything like that, but visibly looking at it. And this is looking to see, is there a problem with the building? Is there a structural defect that we can see that is going to cause a problem down the line, or is causing a problem right away? This needs to be performed by an architect, engineer, or a team of professionals under one of those two. So this is again the milestone inspection. Sometimes we refer to it as a MIR, milestone inspection report is the MIR. Now, the purpose of this is not to check whether the building complies with any particular building codes, fire codes, etc. It's to make sure that the building is literally safe to be living in and that it's not going to have structural defects. Now, when we say defects, I'm not talking about the construction defects. Okay, that's a separate topic. What we're looking for is there substantial structural deterioration of the building? And the only thing that this is supposed to inspect, it's not going to go inside the units and check and see whether someone has their rug in the right spot. Okay, what we're looking at is the building structurally sound? All right, moving on. It again, I already explained it's not checking whether it complies with any particular codes. Now, obviously, the first thing you want to figure out now that you know what a milestone inspection is, do we need one? And this statute was changed a little bit. You see the underlining here. That was changed just this July 1st. And it's done, this milestone inspection needs to be done if the building or the owner of the building needs to do it if the building is 3 habitable stories or more in height. That habitable portion is what was added. So it says is determined by the Florida Building Code. I don't know that we need that language anymore because it's clear. It's only habitable stories. It used to be that there was a question if you had a garage under your building, does that count towards the 3 stories? Now we know you can't live in that garage unless you're living in your car, and technically you're not supposed to be doing that. So habitable stories means stories that you're residing in. Now, this is only going to be a residential condo in whole or in part. So if you're in a commercial condominium, this doesn't apply. It also won't apply to portions of a, let's say, a mixed use condo or a condominium hotel that are not subject to that residential form of ownership. It might apply to portions of those buildings that are subject partially to residential, partially to commercial. So be careful as to whether or not you are subject to this. Again, if you're not sure if you're subject to it, reach out to your attorney. They're the one that should be telling you yay or nay. This does not apply, as I said, to purely commercial buildings. It also doesn't apply to single family, 2 family, 3 family, or 4 family is what was added this year, dwellings with 3 or fewer habitable stories above ground. So whether you're in a condo, co-op, or otherwise, if it's residential and it's not one of these, purely residential or residential with a commercial aspect that's part of the same building, you won't have to do this. But again, if you're not 100% certain, reach out to your attorney. We talked about mixed use and condo hotels. Now, this talks about the financial responsibility for having this study done. So it needs to be arranged by the residential condo and any owner of a portion of the building, not a portion of the condo, but a portion of the building that's 3 stories or greater, which is not subject to that condominium form of ownership. Everyone's responsible for their respective compliance and payment for that milestone inspection. So the portions that you need to have done, you need to pay for them, is really the answer. And yes, I fully understand we're going a little fast here. Understand there's 180 slides. That means I got to get through roughly 90 of them in the next hour and 40 minutes. So that leaves me about a minute and a half per slide plus some Q&A at the end. So we will go fast. You will get these slides afterwards. The things that I'm adding, you're welcome to reach out to me afterwards. If you didn't get 100% of it, feel free to contact me, but we do need to go a little fast because unfortunately, DBPR has decided there's a lot, and I mean that legitimately, of information that you are required to be taught in this class. All right, when do we need to actually do this milestone inspection? It needs to be done by December 31st of the year when the building reaches 30 years of age. So for brand new buildings, you don't have to do this yet. Doesn't mean you shouldn't, but it means legally you're not required to. Okay, the age of that building determined by the certificate of occupancy. If you can't find the certificate of occupancy for the whole building, maybe because the building's so old, or I know in Miami, for example, there was a flood at several records locations for the county. So some of that record might have been lost. You're going to go by whenever the first available certificate of occupancy for any portion of that building was issued to determine when you need to have this done. If the building reached 30 years of age before July 1st, 2022, you were supposed to have this done by December 31st of 24. And if it's after that date, it's supposed and before December 31st, 2024, you're supposed to have it done by the end of this year. If you haven't reached 30 years yet and you still are, 15 years in, you don't need to have this done yet. Another milestone inspection, once you have the first one done, does need to be done every 10 years after the previous one. If you do it early, understand that doesn't mean you have to wait or that you can wait until 10 years after you should have gotten it. It's 10 years after the last one that you have to perform the next one. So this is, again, the inspection needs to be done every 10 years. Now, the local enforcement agency, basically meaning, your code enforcement department or some building department of your local municipality, which is your city or county, etc., can determine that based on the location and proximity to water. This says salt water, but I've seen it with a bunch of different types of waterways. It should only be salt water, but anyway, um, the local enforcement agency can require this when the building reaches 25 years of age instead of 30. So you might need to do it a little earlier if you're located near salt water and your municipality tells you you have to do it earlier. This used to be part of the statute. It was pulled out because a lot of attorneys couldn't tell what that proximity was. It was based on where the water line is, which is can be extremely confusing. But the bottom line is salt water, in my opinion, and apparently not the opinion of the legislature, tends to deteriorate a building sooner than one that is located where I'm at in Novito, Florida, in the center of the state. Okay, so the goal here is to make sure we're not ignoring the fact that that building might deteriorate a little faster. The local enforcement agency also has the option, not they must, they may extend the due date for that milestone inspection. If you can show that you couldn't do it, you signed a contract, and the inspection can't be completed before the deadline. There has to be some specific circumstance. Now that there are so many people willing and able to do this work, you have to really be able to show that local enforcement agency, I got a contract and they couldn't get out here until a week after. But if you're sitting there and saying, oh, well, we've contracted for 6 months after the deadline, that local enforcement agency is probably going to say, sorry, but you're out of compliance and we're fining you for it and reporting it to the state. So bottom line, take care of this when you're supposed to. The whole purpose is to know whether your building's safe or not. If it's 30 years old, chances are some of this has already been done, but not all of it. Just make sure that you're living in a building that's safe to live in is really what it comes down to. Now, if the report was done before July 1st, 2022, that local enforcement agency may, again, may not must, accept an inspection report that was prepared by an engineer or architect for a structural integrity and condition inspection performed before that date if the inspection report meets what it's supposed to meet as a milestone inspection report. Where you tend to see this come into play is like Broward and Miami-Dade counties. I think a couple of the other coastal counties up here in Central Florida have it, where you have a recertification or a milestone inspection from the county that has to be done. So I think there's a 40-year recertification and a 30 in Miami-Dade and Broward. There are a couple others throughout the state. This is, all right, well, we just did an inspection. Why do we have to pay to do almost the exact same thing again? It makes no sense. And the legislature acknowledges that those inspection requirements exist and is allowing you to use them if they meet all of the milestone inspection report requirements. If it's accepted, then the new date where your 10-year clock starts running is the date when that report was accepted. Okay, we need the milestone inspection. Now what the heck do we do? Once you determine that you need it, you need to provide written notice that the inspection is required to every owner of any portion of the building that is not subject to condo form of ownership by certified mail return receipt requested. You also need to notify your unit owners within 14 days after finding out that you need to have this done and provide the date that the milestone inspection needs to be completed according to the local enforcement agency. If you do this voluntarily, My opinion is you don't need to give that notice. You just take care of it and then you send over the report after all the work is done. Now, there are two phases that we'll get into in a minute of this milestone inspection. Phase one, I mentioned visual inspection. That's it. You get a report of whether they physically saw something with their own eyes or with a drone or whatever they're using that would require further investigation. You might have, cracks in stucco. You might have crumbling concrete somewhere. You might have, bent bars that are supposed to be protecting a patio or a balcony. Whatever they might see, if there's any problem, this phase one inspection being completed is going to lead to a phase two. So the architect or engineer is going to perform that visual inspection. If there's nothing wrong, you do not need to move on to phase two at all. Your inspection is done, and you wait the next 10 years to have the next one done. Okay. The person that does this inspection does need to prepare and submit an inspection report. That phase one inspection is completed within 180 days after the owners receive notice from the local government. What does that mean? You get the notice, you got 6 months to take care of this. Okay, so again, you can comply voluntarily without getting the notice, so you don't have to worry about some of these timelines, or you can wait to get the notice, which frankly I don't think is a great idea. Okay, so phase one is not complete until the person that performed it submits the inspection report by email, excuse me, US mail or commercial delivery service, meaning USPS, FedEx, or something like that, to the local enforcement agency. So this is not just going to the association as a report. This is actually being submitted to the municipality. All right. If there's no substantial structural deterioration, like I said, you're done. If there is, you move on to phase two. Okay, this is a list, and I'm not going to go through it, but it's the list of things that are considered substantial structural deterioration, which is the milestone for whether you need, or the benchmark is the word I was looking for whether you need a phase two inspection. Phase two includes destructive testing if that's needed. So that it may include pulling out chunks of the wall. It may include going through. It may not need to include all that. Okay. But the bottom line is it's being as extensive as needed to ensure that the person that's performing the inspection is aware of all of those potential structural issues. Okay, that needs to be done. If phase two is required, then within 180 days after submitting the phase one report, there needs to be a progress report. Not that you have to have phase two done, but that the person that's going to perform it or is performing it reports back to the local enforcement agency and says, here's when we'll have this done for you. The inspector who completes the phase two milestone inspection report also needs to prepare and submit an inspection report. And again, that's not just to the association, it's also to the local enforcement agency. Now, you might get something on there that says you got to do some repairs. That is what the local enforcement agency is being notified about. That's the reason they're being notified, because they're going to force you to actually do those repairs. So I know that some people will hold off doing this in order to save up some money over the course of maybe a year. But the bottom line is, if you need that work done, it is a structural concern for your buildings. So maybe just get it done and be safe. Now, once the phase one or phase two is done, the person that did it needs to submit a sealed copy of the inspection report with a separate summary of at least the material findings regarding what they found to the association, anyone else that owns a portion of the building in those the mixed use condos or condo hotels or other forms of ownership, and the local building officials. These are the requirements of what needs to be included in the milestone inspection report. Since you're not the one performing it, you're just getting it. We won't take the time to go through those. This is important though. Once you get that milestone inspection report, within 45 days after receiving it, you need to give a copy of the inspector prepared summary, not an association prepared summary saying, we did it and we're good. We don't have to do any work. This is prepared by the person that did the inspection. That goes out by US mail or personal delivery to each unit owner in your building, in your condo. You also need to post a copy of the inspector prepared summary on property in a conspicuous location. Usually that's done wherever you post notice of meetings. and also publish the full report and summary on the website if you're required to have a website. Now, I know if you're working with GRS, you probably have a website whether you need to have one or not. That's just your portal. Okay. This information needs to be on there if you're required to have a website. I'd suggest you put it on there if even if you're not, so that you can just direct people to the website rather than having to produce a copy of this document if they request it during an inspection. And we'll get into records inspections later on. Local government can enforce the repairs. You need to start no later than 365 days after receiving the report if that phase two or phase one say that there are repairs needed. So you've got a year to get started. You've got a year to get the loan that you need or whatever is needed in order to be able to get started on that construction project, find your vendors, etc. And if there's no proof that the repairs have been scheduled or commenced within that 365 days, local government actually comes in and can condemn the building until those repairs are started or done. So, bottom line, just get it done, keep it moving, move on with your life. If you don't get the milestone inspection done, that is a breach of fiduciary duty. We haven't gone through that yet, so we'll go through it now. Each director, each officer, each manager owes what's called a fiduciary duty to the association, the corporation itself. That is the highest duty imposed by law. And I don't say that to scare you, but it is the same as the directors being a trustee of the association. It's that high of an obligation. The good news is, and we'll get into this later in a little more detail, it's kind of a dumbest guy in the room standard that you're judged by. If you reasonably believed that what you were doing was in the best interest of the association, you shouldn't be held liable because there's a business judgment rule that applies and says, well, if you use your best business judgment and not emotion or, deciding arbitrarily or maliciously, then you should be protected as a director. The other thing I'll mention, directors and officers liability insurance, I joke, is your third most important bill of the year. If you don't have that insurance, I would not be serving on a board because you're not protected by the association other than by an indemnity clause that might or might not be in your particular declaration or bylaws. I say third most important. Management's number one, we're number two, and number three is that directors and officers liability insurance. And candidly, that's in the order of who's protecting you most. It's your manager is going to be step one, making sure that you're doing things right. If they can't give you an answer, your attorney is next in line. And then that directors and officers liability policy comes in when you do make a mistake because you didn't rely on the advice of one of those two people, or you've got a crazy owner who decides to sue you even though you did nothing wrong. All right. Moving forward, Florida Building Commission requirements aren't used, so we'll move on. Structural integrity reserve studies. Okay, so we're done with part one of part one. The structural integrity reserve studies are something, and just so you understand very briefly, the MERS and SIRS, structural integrity reserve study is SIRS, these two requirements were put in place because of the building collapse in Surfside in, I think, 2021. And the legislature kind of rushed to put something together, made it a mess, and is on Condo 5.0 is what they call it now, because it's going to be the fifth year that they're trying to make this actually make sense. So the two things that they put in place are milestone inspections, which I think makes a lot of sense. You want to make sure your building is safe. And structural integrity reserves, which I don't think makes sense because you're now forcing people to put money away that they won't need for a very long time. But without getting political about this, we'll just go into what is required, regardless of my personal opinion. So, a structural integrity reserve study goes a little bit beyond what the milestone inspection does. And it can be done together, but this is a study of all of your structural items and what it's going to cost to replace them or repair them when that's needed and how long it's going to be before that happens. So, Kerstin will get into how you determine reserves a little later on. This is a very specific type of reserve study. So it's physically going out to your property, figuring out what these assets are that the association is obligated to maintain that are part of the structure of your buildings and figuring out how long are they going to last, etc. Now, this is a determination of anything. Look at this last bullet point that we have up here. Anything that exceeds $25,000 and the failure to replace or maintain it negatively affects the structural portions of your building. Okay. Now that $25,000 figure is adjusted automatically or semi-automatically. It's adjusted by the division, which is a state entity, for inflation on an annual basis. Okay, so right now it's 25,000. This is underlined because that number was just increased from 10,000 last year to 25,000 this year, which is good because this means that there's not quite as much that's considered a structural integrity reserve. We'll get into why that's good in a little bit. Okay, but any of these items, basically all of your structural items, are what you need to reserve for. Now, how the electrical systems are a structural item, I couldn't tell you. A lot of the things that were in there before made even less sense than that, so we'll just leave it where it is for now. Now, do we need it? The answer is pretty much the same as who needs a milestone inspection report. So I'm not going to go through those things in detail, but again, any portion of the building that meets these requirements will need to have that structural integrity reserve study done. This is done also at least every 10 years, and we'll talk about that timeline in a little bit. But again, it's 10 years after the condo's creation for each building on the condo property. So this is actually going to be required far sooner than a milestone inspection, and then every 10 years thereafter. It's based on the visual inspection, just like the phase one of the milestone inspection, which is why some people will do both at the same time using the same vendor. At a minimum, a structural integrity reserve study needs to identify each item of the property being inspected, state the estimated remaining useful life, meaning how long is this going to last before we need to spend more money on it, and the estimated replacement cost or deferred maintenance expense of each of these assets. It also needs to provide a reserve funding schedule with recommended annual reserve amounts that achieves the replacement cost or deferred maintenance expense of each one of these items. Now, the statute was clarified this year to say that pooling of your reserves is allowed for these structural integrity reserves, but you need a separate pool for the structural components and non-structural. I believe Kerstin will get into that later, but I do want to point it out. The other thing I want to point out for the milestone inspection report, the structural integrity reserve study, the statute was also changed this year with respect to conflicts of interest. Anyone that wants to bid out the physical work that needs to be done pursuant to that milestone inspection report needs to disclose that when they're signing the contract for the milestone inspection. Because what we've seen is a lot of vendors who are maybe incentivized, is the way that I'll put it, to include work that needs to be done with the understanding that they're going to be bidding out that work. And whether or not that work is necessary or not, or if it's kind of like going to that shady car mechanic where, oh yeah, you need to, replace your Gazinkazoid. Okay, what is that? I don't know what that is, but I guess I need to get it done. That's kind of some of what we're seeing, not frequently, but frequently enough that it was worth making a change in the statute. So again, if someone that wants to perform your milestone inspection is going to consider performing the repairs as well, because keep in mind, or at least participating in the repairs as the engineer or architect in charge there, they need to disclose that when they're contracting to perform the milestone inspection. Now, the wrinkle that comes up is that this just kicked in July 1st. And so there's no clarity whatsoever if someone was already contracted to do the work or already did the work, what we're supposed to do there. My perspective is if the contract hadn't been negotiated and signed before the statute kicked in, you might be able to get around that by disclosing after the fact that there is a conflict. Okay. But there's no clarity in the statute, which tends to happen when people that know this area of law are not actually consulted before the laws go in place. Who can perform the structural integrity reserve study? Almost the same. Engineer, architect. The difference is this is not a group under an engineer or architect. This is a person certified as a reserve specialist or professional reserve analyst that can do it instead of an architect or engineer. So for a milestone inspection, architect engineer group performing under them. For the structural integrity reserve study for the CEUs, it's one of those two people or a reserve specialist or professional reserve analyst. And that is a profession that is fairly well known at this point. So it's a legitimate thing. Conflict of interest is already here. We already talked about it, so we'll skip it. Now, the other portion that I didn't mention, the contract is voidable if the contractor didn't provide that written disclosure. Okay. and they may be subject to discipline for failure to disclose that conflict. So this is the change that came in this year. The deadline to complete the CERS on or before July 1st, 2022. If you were in existence and are owner controlled, you need to have it done by July 31st of this year. Now, this creates a little bit of craziness because it was July 1st, 30, sorry, let me back up. It was that you need to have it done by December 31st of 2024 until July of this year. So I actually have one client who was required to do it by December 31st, 2024, didn't get it done because they had contracted for it, but it wasn't completed, was not in compliance from January 1st of this year until July 1st of this year, or I'm sorry, until June 30th of this year, when this new law kicked in and extended the date out to December 31st, 2025. Effective July 1st, they were suddenly back in compliance and had another 6 months to get it done. Bottom line, just get it done. It's not difficult. It's expensive. I understand that, but it's something that needs to be done. If you are required to complete the milestone inspection on or before December 31st of next year, based on the age of your building, you can complete the structural integrity reserve study at the same time, but both of them need to be completed by December 31st, 2026. No extensions can be given on that deadline if you're doing them both together and waiting for the CERS. If the milestone inspection required or an inspection completed for a similar local requirement was performed in the past 5 years and meets CERS requirements as well, just like the milestone, that report can be used in place of the visual inspection portion of the CERS. So you can kind of combine everything together to save a little bit of money. If this is effective July 1st of this year, if the association completes a milestone inspection or an inspection completed for similar local requirements, you can delay performance of a required CERS for no more than 2 consecutive budget years immediately after that milestone inspection to allow the association to focus those finances on actually having the repairs done. Okay, so it's not just, well, we're going to go ahead and hold off on our CERS. It's we can hold off because we're already spending money, and it doesn't make sense to have that structural integrity reserve study done when 5 of the components that are going to be listed are going to require an update within a year because we're already getting the work done. Okay, we have it. Now, what do we do with the CERS? Within 45 days after receiving that CERS, the association needs to give a copy to each unit owner or deliver notice that the CERS is completed and available for inspection. So this is different from what I said for the milestone inspection. Okay, a copy of the study or notice need to be sent by U.S. mail or personal delivery. You're going to do U.S. mail, of course, to the address provided by the owner to fulfill those notice requirements. Or if someone's opted into email notices, you can just email them a notice that this is available. You also need to provide the division. This is also different. You're not giving it to the local enforcement agency. You're giving it to the Florida government. Okay, this is a statement that the study was completed and the association provided or made the study available to the owners. It needs to be provided in the manner established by the division using a form that's on the division's website. This is up and running. You can submit it. What I will say is the form asks a lot of questions that are not statutorily required. It also contains a space for you to actually upload your structural integrity reserve study. You do not have an obligation to upload that document. I just want to be clear on that because the division has not been clear on that on its website. That needs to be maintained for at least 15 years after the study is completed. Makes sense. Some of that work will not be done for more than 15 years. So you want to be able to see what are we actually supposed to be doing. If you need to have a website, that CERS needs to actually be posted on the website or the app. And this is a new one for July 1st, 2025. An officer or director needs to sign an affidavit acknowledging receipt of the completed CERS. So this is not your manager. This is specifically your secretary or president usually. Okay. So make sure that if you've received it, you're signing off and putting that affidavit in the official records. Again, failure to obtain this willfully and knowingly is a breach of fiduciary duty. Okay, if the association's required to obtain the CERS, the reserves need to be maintained for the CERS items that the association is responsible for under the declaration. What does this mean? You cannot waive or reduce or use your structural integrity reserves for another purpose. You can still do that with a majority vote of the members for your non-structural reserves. But for these structural reserves, once they're established, they only get used for the components listed in that structural integrity reserve, and you have to reserve the correct amount pursuant to the last study you got. That doesn't mean you can't get an update if you think that study is no longer accurate. Matter of fact, you should. And a lot of the companies that are doing these will actually contract for, 5 years out to update it whenever it's necessary. But keep in mind, you can't just decide unilaterally, yeah, we don't think that's accurate anymore. We're going to go and do what we want to do. You can increase it for inflation every year, but you can't reserve less than what's in that structural integrity reserve study. Okay, well, I already covered the other two, so let's move on. Okay, so you're required to maintain reserves for anything that's on that reserve study other than these items. Okay, if you can't figure out how long this is actually going to last, and when I say you, I really mean the person that's doing the study can't ascertain the estimated useful life of this asset, or your estimated useful life is more than 25 years. That might be a roof that's good for 40 years. It could be the foundation of your building, whatever it may be. And by the way, that's not a structural integrity reserve anymore, but I mentioned it anyway. The association doesn't have to reserve replacement costs for those items, but you do need to reserve the amount of deferred maintenance expense, which is recommended by the structural integrity reserve study. So you're reserving only what it'll cost to maintain these items, not what it'll cost to replace them. Okay. So until you have less than 25 years left on that roof, you don't have to put the money away. Now, as a practical tip, okay, you should anyway. The reason for that is I cannot count how many roofs are 40, 50-year roofs and 20 years in with no damage to the roof, no issues whatsoever, perfect maintenance. Insurance companies are requiring that they be replaced. And if you don't consider that factor and other assets of the association as well, you don't have almost an additional reserve for that. Keep in mind that you're going to end up having to go out and get a loan in order to just pay for the repairs that aren't necessary but are being mandated by your insurance carrier. All right. I already talked about all this. The other thing is you need to fully fund your reserves. So what that means is anything that's in that structural integrity reserve study for that fiscal year needs to be included in your budget. That does not mean fully funding reserves does not mean that in year one, you have the $100,000 that you'll need in year 20 to replace that roof. It means that whatever your reserve study says you need to have, that's in your budget. So I do see that being confused pretty frequently. Let's see. Okay, this one's new for this year for a budget adopted on or before December 31st, 2028. If you've done the milestone inspection within the last 2 calendar years, the board, upon approval of a majority of all members, can temporarily pause for no more than 2 consecutive budgets your reserve funds or reduce the reserve funding to fund repairs recommended by the milestone inspection. If you do that, you need to have a service performed prior to initiating funding to recommend an updated funding plan, meaning you get an update after the work has been performed. Anytime you have, I would say, pseudo major work done on your buildings, you really should get an update to that structural integrity reserve study if it's a structural component. Service reserves can be funded by regular assessments, special assessments. This is what's new. Lines of credit or loans can also be used in lieu of putting that money away. So if you've got the money available immediately through a loan, that's good enough to not have to physically have your members pay in all those dollars. And there are plenty of association focused banking institutions that are providing that service. A special assessment line of credit or loan requires approval of a majority vote of the total voting interest of the association. This is a little bit crazy because your governing documents may say that you don't need that vote. And now the legislature is saying you do. So you're going to want to run that by your attorney as to whether or not their opinion is that you actually need the vote that the statute requires, or if your governing documents for some reason trump the statute in this instance. This does not apply to a developer controlled association where the developer unit non-developer unit owners have been in control for less than a year, or an association controlled by one or more bulk assinees or bulk buyers. What this means is that if the unit owners are not in control, you can't just get a loan as a developer or a bulk buyer or bulk assignee of the developer rights so that you don't actually have to fund this ever. Okay. The developer can't take advantage of the members by not having to fund this. That's really what that says. Now, the line of credit or loan needs to be sufficient to fund all previously waived and unfunded portions of the reserves and the most recent CEUs. So it's not just get a loan for the amounts you want. Excuse me, it needs to be this type of amount where everything that was previously supposed to be in is covered. The funding needs to be immediately available without further approval by the members. And that's just going to be a function of the way that the loan is actually set up for you. Using reserves for a different purpose, I mentioned already, you can do this only for your non-structural reserves, and it has to be with a vote of a majority of all members. Now, keep in mind, if you've got the authority to suspend voting rights and you've suspended voting rights, and Kerstin will get into that later, those votes don't count towards the majority of all voting interests. So if you've got 100 members and 10 of those members have been suspended and have their voting rights revoked temporarily, you've now got 90 members to vote on this. You need at least 46 of them to be a majority. I mentioned pooling of reserves is allowed. This is where you have multiple components. So your roof, your windows, your sliding glass doors, your balconies, they're all in one pool. You can fund your reserves this way officially now. But the CEUs reserves need to be completely separate from that pool of non-CEUs reserves. The alternative to a pool is just a straight line method where every asset has its own reserve. You cannot commingle the funds. You can't use them for another purpose. It's the pooling method is more of a we're just going to have the funds available for whatever we need when we need it. Straight line is every single item we're going to put this money away, and usually tends to result in higher overall assessments. But it guarantees a little bit better that the money is there for each asset when you need it. Local government intervention. This is as of last year, the local building official determines that the condo is uninhabitable due to a natural emergency. You can pause your reserves or reduce your reserves and use whatever money you've got available to make the building habitable based on the board's determination of what is in the best interest of the association. So again, this is not, we'll talk about your emergency rights later on. This is where it's a specific emergency for your condo, not for the local area. All right, what else? The developer is required to turn over a structural integrity reserve study at turnover. Okay, well, when I say at turnover, it's within 90 days after. Unit owners need to disclose what's going on to prospective purchasers. And because some of this is not association specific, I'm going to be very quick about going through it because, frankly, it's not the association's responsibility. Let's see, disputes regarding the milestone inspections and CEUs. Now, this has been in the law for 2 years already, but it's not effective until July 1st, 2027. This is basically saying there is no mandatory non-binding arbitration. The claims that the association didn't do what it was supposed to do with respect to milestone inspections, structural integrity reserves, and funding of those reserves, or making the repairs that are required under the milestone inspection report, those are going to be subject to pre-suit mediation. As of now, failure to do it, there really is no provision because this hasn't kicked in yet. So my guess is it's going to go to arbitration or straight to litigation. I would prefer that everything go to mediation in hopes that we can work it out before we get to the point of actually filing a lawsuit. All right, moving on. Topic 2, elections, which we have a complete separate class on, so I'll be a little bit brief on that, as well as official records and record keeping. Elections are first. When do we need one? Well, whenever there's a vacancy on the board caused by the expiration of a term, that's when you need one. A vacancy on the board that's caused before the expiration of a term is generally going to be filled by, and it says you can either have an election or have the majority of the remaining directors vote, why would you go through the expense and time of what I'm about to describe as the election procedure in a condo or co-op rather than, okay, well, we have a board meeting and it's done. The only reason I would suggest at that point is if you can't find anyone to serve and you're just praying someone shows up at that meeting. That's really it. Okay, so here's the timeline for a condo or co-op election. Um, not less than 60 days before the election, you provide a first notice. This is essentially just saying here's the time, date, and location of the meeting. If you want to serve as a potential candidate to be a director, you need to submit your notice of intent to serve as a candidate no later than 40 days before the election. So any notice of intent to serve as a candidate that's received less than 40 days before the election needs to be discarded. It's received too late, they screwed up. So make sure that if you're on the board and you're having an election and your seat is up, you're actually submitting that even though you're already on the board. Okay. Um, if the candidates provide that information sheet that you're allowed to give, which is basically an 8.5 by 11 sheet giving whatever information you want to share with the members, whether it's actually information about you or just trashing the current board, which I think is a little bit absurd, but that is what people do. And you can't modify that at all. You just have to send out what they sent. Consult with your attorney if you disagree with that statement or you think that it's completely unrelated to the election. But generally speaking, not less than 35 days before the election, the members that want to serve on the board or the people who want to serve on the board need to provide that information sheet to the association. Now, the last step before the actual election itself, not less than 14 days or more than 34 days before the election meeting, the association needs to send out a second notice of the election along with all those candidate information sheets, along with a proposed ballot, along with an inner envelope and an outer envelope. We'll talk about those envelopes in a minute. So that is the package that goes out, and the timeline is not less than 14 days so that you're giving 14 days notice, not more than 34 days so that everyone has the opportunity to give in their information sheets in time. Now, the number of directors, unless the governing documents say otherwise, usually this will be in your bylaws. A board consists of 5 members. Now, if you have 5 or fewer units, the board is at least 3 members. If the articles or bylaws allow you to serve terms of longer than 1 year, the terms expire at the annual meeting. Now, if the condo is a timeshare or non-residential, you're subject to different rules. Staggered terms don't expire until whenever they expire. And if all directors' terms would otherwise expire, but there are no candidates, the board just rolls over and stays on. In other words, if there are not enough candidates to serve on the board to fill all the spots that are available, or if the people that are submitting are an equal or lesser number than the amount of open spots, you do not need an election. The people that submitted their names, as long as they're eligible to serve, are going to serve next year. That also means that if that one director wanted to stay on but was late and someone else submitted on time, the person who submitted on time is going to replace that candidate or replace that director. There are term limits that haven't kicked in yet. Well, I say that because it's starting July 1st, 2018, when this law kicked in. A director can't serve more than 8 consecutive years unless approved by 2/3 of all votes cast in the election, or if there are not enough eligible candidates. Now, that means that this kicks in July 1st, 2026. What has not been made clear, despite the fact that it's been 7.5 years or 7 years since this law took effect, is whether if someone is midstream, so to speak, meaning they're in the middle of their term, and that 8 years has expired, whether they're now off the board or they serve out the rest of their term. As a practical consideration, something you might consider because the loophole hasn't been fixed yet, technically, my opinion, if someone drops off the board and is then reappointed 2 days later, their term wasn't consecutive anymore. They didn't serve for that 2 days. So they can now serve. I don't like the idea of them serving another 8-year term, but it may be a way of getting around having to have an election in the middle of someone's term. All right, moving on. In a residential condo with more than 10 units, which is, I think, about 90% of them in Florida, co-owners of a unit can't serve as directors at the same time unless they own more than one unit or there aren't enough eligible candidates to fill vacancies. Now, we talked about election by acclamation. That's where if the number of vacancies is the same or more than the number of candidates, meaning there aren't enough people to require an election, you don't have to have one. There's no quorum requirement for a condo election, but at least 20% of the eligible voters need to vote in order to have an election. Okay, so if you have less than 20% of the members that actually submit their ballots, you do not have an election. Elections are decided by basically majority wins. That's what a plurality of votes ballots cast means. Every document, every piece of paper, including those envelopes from the election, is an official record of the association and it's maintained for 1 year from the date of the election. Okay. The election or until the next election if you don't have one. So if you don't have an election this coming year, you still need to save that for another year until the following election. Now, election challenges need to be brought within 60 days after the results are announced. If you wait till day 61, you've waived your right to challenge the result of the election. Usually, that challenge is going to be based on the procedure. It's not going to be based on, I don't like the outcome. Okay, if you don't like the outcome, try and put together a recall after those 60 days expire. We'll talk about recalls later. But if you wait more than 60 days, or your challenge is not based on the procedure of how the election was done, how the ballots were cast and counted, etc., you're going to lose, and it's a wasted challenge. Okay, I mentioned eligibility earlier. In other words, only people that are eligible to serve on the board can be candidates. There are a couple things that will cause you not to be eligible. Okay, first, you didn't submit in time. Anyone that's delinquent in payment of any assessments due to the association as of the deadline to submit your notice of intent, so that's that 40-day deadline, is not eligible to be a candidate. Someone who's been suspended or removed by the division under the Condo Act, meaning you did something that's an actual criminal violation under the condo statutes, is not eligible to serve. If you were convicted of a felony or something that would have been a felony if it was committed here in Florida and haven't been out of prison for at least 5 years on the date that you seek election, you are not eligible. Now, this last sentence of that one is one to note. The fact that you didn't do, and I get this question a lot, well, if that's what the statute says, how do we figure out whether someone has that eligibility or not? It is not the association's responsibility. It's not the board's responsibility to ensure that you run a criminal background check on every potential director. Some communities do it, some don't. Frankly, I think it creates more risk than it avoids because you might find the wrong person with the same name who committed a bunch of crimes, and now you're keeping someone off the board that belonged on the board and costing the association a bunch of money for no reason. Okay, but if you let someone on the board that shouldn't have been on for this reason, any decisions that were made, including by that director, before you find out that it's a problem, are still valid. So it doesn't invalidate anything that you've done. And then again, if a criminal charge is pending against the officer or director for forgery of a ballot, theft or embezzlement of association funds, obstruction of justice, again, the things that are criminal penalties under the Condo Act, they may not be appointed or elected as an officer of any association, regardless of whether the crimes pertain to this community or not, and may not have access to official records of any association except by court order. So if you know that this person is under charges and being considered, not just John Smith down the road said Jim did something wrong, but there's an actual criminal charge that's been brought. At that point, this person is not eligible to serve on the board, and they're not eligible to obtain official records through an inspection except by court order. The vote is generally by secret ballot. So I'll explain how we do the inner and outer envelopes now. Okay, when you're actually going to be counting the ballots, they should be submitted where you have one ballot only in the inner envelope, one inner envelope in the outer envelope, and those are all submitted separately. Okay. That's for secrecy. Now, my opinion has always been you want to count ballots if you can. And so if someone submits with writing on the inner envelope or on the ballot identifying who it is, you still count that ballot, but they've waived their right to be anonymous in how they're voting. Okay, but when you are counting these ballots, you're going to start by having all of the outer envelopes in a pile. You have an independent group that's not directors, not officers, not the manager, but is separate and apart, and not their family members. Okay, that group is going to sit at a table, opening the outer envelopes, putting the envelopes aside, putting the inner envelopes in. Okay, if there's no inner envelope and it's just a ballot, okay, you waive anonymity, that's fine. Move the ballot off to the side, move the inner envelopes off to the side. Once you've opened all of them, you should be moving them off into a box somewhere. The outer envelopes go in a box, and you move on and count or move on and open the inner envelopes. Now, I missed this step, so I apologize. I'm going to step back. The first thing you should be doing is checking checking the outer envelopes against your roster. Those outer envelopes are going to identify who's voting. They're going to be signed, and they're going to include the unit of the person that's voting so that you can check and see whether they're trying to vote twice, but they only have one vote, etc. Anyone that tries to vote twice that has two ballots submitted should have that ballot, both ballots actually, disregarded. Okay. And you literally write disregard two ballots submitted because you can't tell which one was submitted properly. Now, you do have people that'll submit a ballot for multiple individuals so that their ballots don't count. Be careful about that and run that by your attorney. But bottom line, you're going to check off, figure out whether all of the outer envelopes are valid. Any ones that are not, you put off to the side, keep in a box. Okay, then you go through the process I just mentioned. You separate the outer envelopes from inner envelopes, move the outer envelopes into that box. Okay, if there's more than one inner envelope in an outer envelope and that person doesn't have more than one vote, you disregard all of them. Then you open the inner envelopes. Any inner envelope that has more than one ballot in it, disregard. Because you can't tell anymore, now that you've separated, whose ballots they are and whether that person has more than one vote. Okay, but now that you're done separating the inner envelopes from the ballots, the inner envelopes now go in a box. Because again, these are official records. And finally, you're going to count the ballots, figure out who won. That's the whole process. All right, so I already went through most of this. An owner that needs help casting the ballot for the reasons stated in the Fair Housing Act of Florida can obtain that assistance. We talked about this already. Okay, a person who engages in a fraudulent voting activity related to an election commits a first-degree misdemeanor. It is a crime to forge ballot envelopes, threaten, bribe, or intimidate someone to vote for you in an election or not vote for someone in an election. If you care that much about a condo election in Florida, you probably need to get a hobby. I know that this happens. I know that people want control, but the bottom line is, I don't get it. Now, if you forge that ballot envelope or voting certificate, that's even worse. That's a third-degree felony. Okay, so voter fraud in condos and co-ops is a crime. Electronic voting, I won't go through in detail other than to say I think it's a great idea to get it going in your community. It enables people to vote basically via an app or a website. You can click through instead of having to actually physically mail back a ballot. It also saves a ton of time in counting because it's done electronically and automatically for you. It'll also get a lot of people to vote, especially if they're international or if they're not local. And one of the things that you can do, because everyone that's going to vote electronically has to actually opt in to be able to do that, and for the board to be able to accept their vote, have them elect to opt in if they choose to as part of your closing process for any unit sale. That way, even if they are international, they're seeing this right away. They're seeing that this is an option. They're seeing that they can have control just by clicking through on the app that your electronic voting vendor uses. And it's much easier to get people to show up when they don't have to physically show up or physically mail something. Because let's be honest, people are lazy. This is Florida. We've got tons of international buyers, tons of people that have second homes that don't live in the community. Even if someone lives in New York, the likelihood that they're going to submit a written ballot to a Florida Community Association is surprisingly low. So I would suggest if you're not already doing this, and especially with some of the changes in the way that meetings are supposed to be run in general, I would just suggest that you consider this. There are plenty of vendors out there that provide this service. We can connect you with them if you'd like. Now, the change in the law over the last year is that if at least 25% of the voting interest of a condo petition the board to adopt a resolution for electronic voting for the next election, the board needs to hold a meeting within 21 days after receiving that petition to determine whether to do this. You need to receive the petition at least 6 months after the date of the last scheduled annual meeting. Okay, so if you can't require this until it's roughly 6 months before the election or closer, and it's got to be 25% of the members of the condo. This doesn't say explicitly that the board actually has to agree to use electronic voting, but frankly, my perspective is take care of it before you have to get this petition. It's only a benefit. The cost, if you're using the right vendor, will basically equal what it would cost to mail out all these notices. And they'll actually go out and try and get everyone to sign up for electronic voting as a vendor because they make money based on how many doors actually go with this program. This is absolutely insane to me, but the legislature does things sometimes seemingly without thinking of the consequences at all. If you don't have electronic voting, and this is another reason to have electronic voting, by the way, the association needs to designate an email address for receipt of electronically transmitted ballots. The unit owner can electronically transmit the ballot to that email address without complying with the rules providing for secrecy of ballots adopted by the division. The unit owner needs to transmit the ballot to that email address no later than the scheduled date and time of the meeting. There's a rebuttable presumption that the association reviewed all folders associated with the email address that they designate if a board member, officer, or agent of the association or the CAM provides a sworn affidavit saying that they reviewed to get all these ballots that were emailed in. What it doesn't require is any kind of registration. This is not necessarily the email address that you opted in with. Anyone can submit from any email address a ballot that contains the information that needs to go in it. Let me see if we provided. Yeah. So it needs to have a space for the unit owner to type their unit number, first and last name, which is also treated as the signature of the unit owner. And this statement in capitalized letters about waiving secrecy of the ballot by submitting it this way. It doesn't need to be verifiable in any way, shape, or form. So if you want to avoid what I anticipate being potential rampant voter fraud by submitting 50 different ballots this way from various different email addresses, all of which are not actually the person that's allegedly voting, electronic voting can be implemented and you no longer have to do any of this electronic balloting. This, I think, is frankly wholly misconceived. It's a terrible idea and it is rife with voter fraud. This has fraud written all over it, is the best way I can put it. There is no verification whatsoever and no way to verify that the person that's submitting this actually had the authority to do so. So moving forward, the officers. So there are different hats that you might be wearing in your community. This is a similar but different topic than the election. As a member of the association, you're a unit owner. That's what a member is. Okay, you may be also a couple other things, but you're a member if you own a unit. If you are on the board, you're a director. Okay, the board's responsibility is to make motions, second motions, vote on motions, or abstain from voting if there's an actual conflict. That's all the board does, but it's the most important group in the entire community because they make most of the decisions for the association. Okay, then you have the officers, which is what we're talking about now. This is generally going to be your president, vice president, treasurer, secretary. So when someone says the president of the board, that's Wrong. You've got the board, you've got the officers. They don't even have to be the same people. So it is the president of the association and the directors. They can be the same people, but they don't have to be. So anyway, moving on. Um, the president, secretary, treasurer are required unless the bylaws say otherwise. They're going to do whatever duties are in the bylaws for each one of these, but in reality, 90% of that is going to be done by your manager instead. We talk about the president as being the mouthpiece of the association, the person that signs the contracts. You might have your secretary signing those as well. Usually that's not going to be done by your manager. Then you've got your vice president who really doesn't have to do anything unless something happens to the president. So, congratulations. If you're the VP of your association, you're basically just a director, most likely. And then treasurer is the person that's supposed to maintain the funds, maintain the accounting, the financial reporting. But again, your manager is probably going to do that. So, good for the treasurer if that is their responsibility. And then finally, the secretary keeps the records, keeps the documentation, etc. But again, your manager does that instead. So those are generally the officers. The important thing to note here is that these people are selected by the board. The board is selected by the members. The officers are selected by the board. And this is the only secret ballot deciding who the officers are that the board is allowed to use. Okay, because otherwise everything's supposed to be open unless it's specifically a closed meeting. There's no prohibition against changing officers midterm. This is really important. So when you've got that president that thinks that they're authorized to do whatever the heck they want, and they're going out and knocking on doors and saying, hey, you need to put that stuff away. I'm here on behalf of the board. I'm the president, and you need to take care of that because the association says so. And they won't cut the crap. Take them out as president. Just put it on the agenda for the next board meeting to have a vote of the board to reassign officer responsibilities. Now, if you've got a 5-member board and 4 officers, that person doesn't even have to be an officer. Okay, they can just be a director at large, is what a lot of people call it. But there's nothing that says you can't switch gears mid-year and make someone who was the president the vice president with no authority or just not an officer at all. Disqualification from service. This is when you're already on the board, but you're getting kicked off. So don't do these things is really what it comes down to. Kickbacks. Okay, that's a third-degree felony. When you try and accept, or offer to accept a kickback, meaning something of value that you're being offered because of your position on the board and your ability to make something happen. This is where, you're having a painter come in to paint the outside of the buildings, and they're also conveniently going to paint your inside of your unit at a discount. Okay, there's nothing wrong with using that same vendor for work on your particular unit, at your particular business, etc. That's not a conflict of interest. But if you're getting any kind of discount for the work, or if you're getting it for free, that's a kickback. It's illegal. It's a third-degree felony. Don't do it. An officer or director charged, again, by information or indictment, meaning there are actual criminal charges for any condo crimes, is removed from office. If the charges are resolved without a finding of guilt before the term is over, that director is reinstated. So you can fill that director's seat by either an election or having the board just decide who to put in that seat. Okay, but what you can't do is just leave them on the board after those charges are filed by a prosecutor. So again, this is not there was a criminal complaint filed by John down the hall. This is there was an actual prosecutor willing to file charges with a court and the charges are still pending. And again, if that person's term hasn't expired by the time that there's a finding of not guilty or the charges are dropped, they jump back on the board even though someone was appointed to fill that slot. If their term expires, that term is up for reelection, just like it normally would be. Anyone that's more than 90 days delinquent in payment of any monetary obligations due to the association, they're treated as abandoning their seat on the board. Now, keep in mind, I have a lot of people ask, well, what do we have to do to report this to the person? My answer is you have no obligation at all other than to send an email saying you're off the board. Sorry, you should have paid your assessments or other monetary obligations to the association. Anyone that willfully or knowingly or intentionally violates official records inspection requirements commits a second degree misdemeanor and must be removed. Now, keep in mind, last year this was willfully and knowingly. I think it was more than twice in a year. Now it's if you do it at all. This is a crime and you're off the board. So don't do it. And meaning don't refuse to provide records to protect yourself from being prosecuted for other crimes. Don't deface or destroy records to protect yourself. That is what we're talking about here. And again, defacing or destroying accounting records or fail to create or maintain accounting records with the intent of causing harm to the association or any members is a first degree misdemeanor, civil penalties, and you're out, meaning off the board. Anyone who willfully and knowingly refuses to release or otherwise produce association records to avoid escape, detection, arrest, trial, or punishment for commission of a crime or to help someone else is a third degree felony. That's obstruction of justice. This one's ridiculous and it's an easy thing to avoid, but here it is. We had this come about, I think it was 7 or 8 years ago, using a debit card issued in the name of the association or billed directly to the association for anything that hasn't already been approved in the budget or approved in writing in meeting minutes by the board is considered theft in the amount of whatever the purchase was that was made. Now, when I say there's an easy way around this, do not use a debit card in the name of the association. Do not use a debit card billed directly to the association. Use your own debit card and get reimbursed for proper expenses, or use a credit card that's not subject to this law at all. I know that I've heard a lot of people saying, oh, well, my bank won't give it. Make sure you're banking with an institution that has an association branch and understands how associations operate. Don't go with just the typical, oh, well, we do corporate banking, so we can help you. That's the same thing as going with a real estate attorney instead of going with someone who specializes in this area of law as your association counsel. It's not a wise move. They maybe handle it, but they're not going to know the ins and outs and the day to day of what you deal with on a daily basis, like an attorney or a manager that does this all the time would know how to handle. So, again, just go with vendors that specialize in this area of law. There are enough of them out there that you can still get your three bids in almost every aspect of your practice. But, going with the guy that John, who's on the board, happens to know that is a family lawyer, or the guy that does landscaping for individual lots and doesn't do commercial, just because you know someone doesn't mean they're the right fit for your association. That's just a practical tip. If there is a violation of conflict of interest requirements that we'll talk about later, that officer and director is removed. No criminal penalties there necessarily, but there might be civil. And those penalties are the basis of a lawsuit, not just the state coming down on the person. Failing to timely file the written certification and educational certificate that you'll get after this class is also a reason to remove someone from the board. So you had 90 days after you were elected or appointed to the board to take this class, get your certificate in with your manager. Make sure you do that. Failure to have that on file doesn't affect any board actions that were taken while it wasn't on file, but it does mean that that person is off the board, suspended. So that's another one where they'll come right back on after that certificate goes into the official records, regardless of whether you fill that spot or not. All right, condo association websites. If you have, and this is as of now, 150 or more units, you need a website. Now, 90% of this is going to be, frankly, a waste of your time because if you're with GRS or any other major management firm, they're going to take care of your website requirement using their management portal. But I'm going to go through it anyway in case you're not with one of them. And if you're not, I would suggest that you consider having a manager because, frankly, it just makes everyone's lives easier, including your attorney. So if you have 150 or more units, you need to have a website to post association documents. That was required by January 1st, 2019. Effective January 1st of next year, that requirement's going to apply to any association with 25 or more units, which is, I'd say, at least 75 of the condos in all of Florida. So make sure most condos are going to have a website if they don't already have one. You can choose to work with your manager if you have a manager. If you don't, then you'll need to find a vendor that specializes in association websites or is capable of putting this information out there. Now, anytime I say there are a group of vendors that do XYZ, you're welcome to reach out whether you're working with my community or not. I'll be happy to make some suggestions of who you might consider contacting for these services. I don't have a preferred vendor list. I just have a list of people that I haven't had a problem with yet. All right. On the website needs to be independent, wholly owned or operated by the association. That includes working with management is fine. Needs or it can be a web portal operated by a third party provider that the association owns, leases, rents, or otherwise obtains the rights to operate all of those web pages and on which the required notices, records, and documents can be posted. So you need to either own it or work with management or another vendor to create that website for you. You should own the website rights. You should own the content, etc. I think we might have a website related webinar. If not, Jeff, please remind me to create one because I have so much free time to do that. Moving on. Thank you. The website needs to be accessible through the internet, needs to contain a subpage, portal, or other protected electronic location that uses a username and password to provide access. That way, your records aren't accessible to everyone, just the people that are entitled to it. There's a whole laundry list of what needs to be on the website. My recommendation, if you can swing it, is every official record should go on the website so that you don't have to try and figure out what's there, what's not, what needs to be there, what doesn't. There are distinctions between what goes on the website and what is an official record. I'm not going to go through them because, frankly, I think it's a waste of your time. You can read this slide when you have time. It's all taken directly from the Florida statutes governing these condo websites. All right, so let's see. The one thing I will point out, you do have to have a page on the front that's called notices that includes every notice for association meetings between board and member meetings, the agendas for those meetings, and I think we'll get to the time frame for posting those in a little bit. If not, just I'll try and remember to mention it. The failure to post documents on the website doesn't invalidate any action of the board or of the association. Okay, each association needs to designate someone with a mailing address or street address for purposes of submitting estoppel certificates. And this is actually 718-116, not 1116. But those estoppel certificates we'll get into later. I think Kerstin's going to cover that. That's basically a document that says what needs to be done in order for someone that is going to either get a mortgage or purchase a unit, what needs to be done so that they can come in fresh and clean, meaning they don't owe any assessments, there are no violations on the property, etc. The association does need to ensure, generally by having login credentials, that the information and records that are not accessible to unit owners are not posted on the website, meaning when we get into records inspections, everything pertaining to the operation of the association that's in writing is an official record. But not everything is subject to inspection or disclosure to the members. Privileged information, etc. So any of that information that I think Kerstin's going to talk about later that is not subject to inspection also doesn't need to go on the website. Now, that doesn't mean it can't be uploaded to the website in a separate board-specific section that is only accessible by the board. Again, that just makes it easier for the manager and the board to do the business of the association. If protected information is included in documents that need to be posted, you can redact those before posting them. And in complying with the posting requirement, there's no liability if you inadvertently disclose what is in that should have been redacted, unless that disclosure is made with knowing or intentional disregard of that protection that should have been there. You can use an app instead of a website. I know of a few communities that have both. I would recommend, given the age of some people in Florida and the likelihood that they can use an app, and that is not ageist. My 97-year-old grandfather uses an iPhone 13 that I gave him. I totally understand there are plenty of people that are 97 years old and still capable of calling their great grandkids on FaceTime. Okay, but what I mean is some people are not. So my goal is for this to actually be accessible, or your goal should be for this to be accessible to everyone. And as a result, you can use an app, a website, or my recommendation, if you're going to use an app, is to use both. Okay, well, I was wrong. I'm going to do official records. So the official records, and this is another one it's not worth going into because look at number 22 here. All written records, even if they're not specifically included in this statute, that relate to the operation of the association, meaning everything. This is your catch-all. Now, there are a couple things that were explicitly added to the statute this year, so I'll mention those. Those are 19 through 21. The approved minutes of all board meetings over the last 12 months are official records of the association and need to be produced for inspection when requested. That's in the statute now. I don't know why it needed to be because it was already an official record. This is the crazy one. The video recording or a hyperlink to the video recording for all meetings of the association, the board, any committee, and the unit owners, which are conducted by video over the preceding 12 months. Now, if you don't have this because the law wasn't in place, my perspective is you just explain that fact, and if an owner challenges it in court, I don't think you'll have a problem. But what you do need now is if you are going to have virtual meetings, they need to be recorded, and that recording needs to be made available either on the website and via inspection or via hyperlink, which is the way I suggest it. And a lot of people are just creating a PDF with the hyperlink, and that's the official record. A hyperlink, if you don't know what it means, is basically just the link to something else. So this would be the link to where Zoom is storing that video rather than the association paying extra thousands of dollars to have that separate storage. Just make sure that Zoom is storing that for at least a year so that you're complying with this requirement. And then any affidavits that are required by the chapter, which there are a couple new ones that I already mentioned and a couple more that we'll mention later. There is a minimum retention period. Okay, it's at least 7 years, but certain records that are listed here, which is all the developer documents and governing documents and rules and meeting minutes, basically need to be maintained permanently from inception of the association. Now, if they were already destroyed or gotten rid of pursuant to a prior rule of the association as to how you were going to get rid of those records, I don't see it as an issue. But as of, I think it was either last year or the year before in July, you had no excuse to get rid of any of these documents. The structural integrity reserve study I already mentioned needs to be maintained for 15 years. Bids for work to be performed are at least 1 year after receipt of the bid. All your election records are 1 year. Now, the maintenance requirements effective last year. This is also obnoxious, but it makes sense. All the official records need to be maintained in an organized manner that makes it easier for an owner to actually inspect them. You don't need to, excuse me, you don't need to cherry pick the records that they ask for when they ask, oh, well, I want to inspect the financials from last year. Your response to that can still be, okay, well, you can inspect the records and you can find the financials because now they're organized. The other change last year, or one of the other changes last year, if the official records are lost, destroyed, or otherwise unavailable, the association actually has an obligation to make a good faith effort to recover them if reasonably possible. So you can't just say, oh, sorry, we don't have it. The inspection and copying is a very important one. After you receive a written request, the official records need to be maintained. And when we say written, there's no requirement in the statute that this be by mail, certified mail, return receipt requested, etc. We'll get into the policy you should be adopting in a minute. Okay. But those records need to be made available to the owner and the owner's authorized representative, not or, which is how it was until last year. It's an and. Okay. Within 10 business days after receiving the request and within 45 miles of the condo or the county where the condo is located. Okay. That means that you might be able to do this inspection in the condo if you've got a location to do it, or you might do it in the management office if that's close enough. Renters have limited rights to inspect these records, only the governing documents and the inspection reports. Those are the only things they're allowed to review. Declaration, bylaws, and inspection reports. The association can comply with these records inspection requests by having a copy available for inspection and copying on property or within 45 miles, offering to make the records available electronically via the internet, meaning on your website. Okay, that would make it a lot easier. So my suggestion, like I said, put all the records on the website. Your response to every records inspection request is everything that you're entitled to review is on the website. Have a nice day. Inspection over. Okay, and then finally allowing the records to be viewed on a computer screen and printed upon request is the other option. Now, importantly to note, the owner doesn't have to give you a reason why they want to inspect. So if they say, well, I want to inspect because of this, your answer is, I don't care why you want to inspect. Here's the date of your inspection and the time and location. Or, you can inspect online. You're not going to respond saying you're not allowed to inspect for that reason, or you're not allowed to use the records in a certain way. That goes in your policy, not your response. Okay, the right to inspect the records does include the right to make copies at the reasonable expense of the member. Okay, this used to be that the first 25 pages were free, the rest were 25 cents a page. My understanding is that first 25 pages are free has gone away. So your inspection policy can say that it's 25 cents a page starting with page one. You do need to allow the member or authorized representative, and authorized representative is what this should say, to use a portable device free of charge, meaning their cell phones, scanning, cameras, scanners, whatever. If they're going to make the copies themselves, you don't charge them for that. You need to maintain an adequate number of copies of the governing documents. No one knows what the hell an adequate number of copies is. Again, put it on your website and then you don't have to worry about it. This one, oh, the checklist. So, in response to a written request to inspect records, the association needs to simultaneously provide a checklist of all the records that were and were not made available for inspection and copying. That checklist needs to be maintained for 7 years, and the association delivering it creates a rebuttable presumption that the association did what it was required to do. Now, how you create this checklist, initially reading it, I was concerned when I saw this new statute that hadn't taken effect yet. My concern was, oh my God, we have to have a list of every single record that's ever been created for this association that hasn't been destroyed yet. And the answer is no. I've never seen a judge actually rule that way. As of now, what we're proposing for all of our clients is we can create a list, and frankly, it's the list of what the statute categorizes for all records. So here's the list of the records that exist. We're pulling out all the records that are not subject to inspection for one reason or another and putting them on the list of what was not produced. And that's your checklist for everyone that requests to inspect records. So this is something your attorney can prepare for you as a form. We've prepared, I think my office alone in Winter Springs has prepared about 30 of them over the last year since this kicked in. And if your attorney is not willing to provide that to you, I'd be surprised. So you might want to reach out to them. And if they're not willing to provide forms for you to use instead of charging every time something pops up, it might be time to look at a new attorney. You can create rules. This is the policy I mentioned a little while ago. You can govern the frequency, which is not any more frequent than once a month, is the limitation in the statute and case law. The time, meaning how long you can actually sit in any sitting, the location, the notice, and the manner of records inspections and copying. This also is where you will dictate what the costs are, both for the manager to go through any records to produce them. For the 25 cents a page is the cap on what you can charge for copies. It'll also be where you put in how these records inspection requests need to be received. Are you going to require that it go to the association certified mail return receipt requested so you can prove when it was actually received? Or are you just going to allow for emails and whatever, however it's submitted, as long as it's in writing? At a minimum, you should be putting in there that verbal submissions are not sufficient. If John is at a board meeting and says, I want to inspect this, that's not a records inspection request. That's John telling you something. All right. So the other thing I mentioned earlier, you can't require an owner to show a proper purpose or state a reason for the inspection. The reason that they want to inspect the records is because they're entitled to as a member. Now, again, I mentioned there's a list of records that are not accessible to owners. You're not going to produce these as part of an inspection request response. And these are not going to be on the website. This is what I was talking about earlier. They're not going to be on the website portions that are accessible to all of the members. This is only going to be information that's accessible to the board, the manager, and if applicable, your attorney. Okay, so I'm not going to go through them in detail. Let's see. An owner can consent in writing to disclosure of information that otherwise wouldn't be accessible. In other words, my phone number isn't accessible to everyone, but I want people to be able to reach me, so I'm going to give it out. Now, by the way, I'm not that guy. You can email me. I don't need everyone in my community having my cell phone number. Um, Website posting, you need to ensure that the records not accessible to the owners aren't posted. Again, you can make them accessible to the board only. Again, this is a no harm, no foul unless it was knowing or intentional disregard that you produce protected or restricted information. There shouldn't be any penalties to the association. And the association, this should also be in your policy. Association's not responsible for the use or misuse of the information provided. So when you give someone your member roster that they ask for, the association's not responsible for that jerk going ahead and sending an email to everyone who submitted an email address for purposes of association notices. Okay, that's not the association's fault or responsibility. The association did nothing but comply with its obligation to produce that information for inspection. Attorney-client privilege is a really, 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 really important concept. Okay, this is anything that is privileged is exempt from disclosure. It's not to be produced to the members at all. The attorney-client privilege is a privilege between the association, the manager or management firm, and when I say association, I mean the board, including current and former directors who are subject to the communication. Okay, the board, the manager, the law firm. Now, if you have new counsel, yeah, they can certainly look at that because they're your attorney and they have the same privilege. But anything that's protected by that privilege, which is created either for the purpose of potential litigation or for the risk of future litigation or as part of litigation, or it's just legal theories of the attorney, any of this is not subject to disclosure to the members. Okay. The important part here is this last one. Only the board can waive attorney-client privilege. So I've got some HOA clients where individual members of the board are sharing privileged information with the membership as a whole. That is a dangerous game to play. Okay? Because what you're doing is sharing the strategy of the association potentially with your opposing party. So you do not give that away. They've been threatened several times, and there's a recall pending against one of the directors. The other one that I've been dealing with for a while is now off the board because they got voted off for sharing that information and blowing the strategy of the association. Okay. So it's the board that votes and decides to waive the privilege. I'm not allowed to waive it as your attorney. Management is not allowed to waive it as your manager. Individual directors are not allowed to waive that privilege. It's a board decision whether to waive that privilege. If you don't provide the access to official records within the 10 business days, you give what I call a $500 gift. And I don't want to give that gift. Okay, so this is $50 per calendar day starting on business day 11 that you are obligated to pay to someone who doesn't receive those records or the inspection within the 10 business days. Now, I want to be clear. When they submit that request, that 10 business days starts as soon as you receive it, and you need to produce the records, not just schedule the inspection within the 10 business days. So you're not going to write on business day 9 and say, oh, your inspection's scheduled for business day 15. That's not good enough under the statute to avoid this type of penalty. So you need to make sure that within those 10 business days, if it's your manager, fine. If it's the board that doesn't have a manager, fine. But you are scheduling that actual inspection for some time within the 10 business days, even if it's on business day 10. If not, you have a $50 per calendar day up to 10 days, again, 500 total, plus attorney's fees and costs that you owe that owner if they spend any attorney's fees. So let's avoid that. We already talked about all this, so we can skip it. We talked about all this, so we can skip it. An outgoing board or committee member needs to give up all official records and property within 5 calendar days after the election that pulls them off the board. If you don't do that, you are subject to a civil penalty imposed by the division. You might also be subject to a lawsuit to have those records turned over immediately, which means more fees and costs that you're paying the association. Now, my portion is now done. I'm going to go ahead and if I can figure out how, yep, there we go. Stop the share. And we'll go ahead and jump into the Q&A. I see that there are about 8 questions. So I'm going to jump through and, I don't know, Jeff, Courtney, if you want to ask the questions or if it's easier for you if I just ask them to myself, which is a little awkward, but that's fine.
I,
We,
if it's easier for me to read them off to you, Alan, I can do that.
Yeah, let's do that, please.
All
And,
right.
can I mention one
obviously,
thing about the
yeah, go ahead.
websites earlier that can potentially save some of these associations money? And no disrespect to any company that does websites or anything, but if you make sure your website is responsive, meaning it conforms to any size of your screen, and somebody's trying to pitch you to purchase an app in addition to your website, there's really no need for that because responsive websites will conform without losing text size to the size of your small phone screen. So, in essence, a responsive website acts just like an app. So, I just wanted to throw that in there, but didn't want to interrupt you earlier.
No, great point. I appreciate it.
Awesome. Thanks. Okay. I'm just going to go from the top. So first question from Jackie. If a condo has the CERS done, published, etc., before the certificate was required, should one still be executed?
So your vendor is going to say no. I'm going to say yes because this is just more work. Now if you're talking about Jackie and good to see you, the certificate that is required to be signed by director or officer that I mentioned, I would say still do it because it's not going to cost you anything other than 5 minutes of your time. And frankly, to avoid potential risk, even though that potential is minimal in my opinion, I'm always of the opinion if it's something that can be done, I mean, you're still going to go back to saying it was sent on whatever date. You're not going to forward date it to the date that you signed the affidavit, but having that affidavit protects the association, so I don't see a reason not to do it. As long as the facts that are given in the affidavit are accurate. That's the only concern.
Cool. Okay. Dominic asks, can you please confirm changing from straight reserves to pooling reserves only needs the board vote?
So that was actually changed just this year, and that is correct, Dominic. In order to change from straight line to pooling for CERS reserves, you only need to have the board vote. It's not a member vote anymore.
Awesome. All right. Jackie asks another question. And I think somebody else asked this question as well. If a new board member has not taken the required 4-hour class and is now considered inactive, how long do they have before removal?
0 seconds. They're off the board, period. Now, again, this is, and hi again, Jackie, this is just a suspension. So this is, you are off until you take the class and get the certificate into the official records of the association. So it's not you're off until the next election. This is not a recall. It's not a criminal violation. It's hey, you know what? If you want to get back on, take the class you were supposed to take. Take the 4 hours that everyone else took and do what you're supposed to do. And then you'll be back on as soon as you get us the records, as soon as the certificate's in the records.
Okay. Dominic asks, can a board member be removed and what are the steps to follow?
That's called a recall, and that is, well, it's a recall unless they've done something that is subject to removal under the statutes that we've mentioned so far, the ones that Kerstin will talk about. And Kirstin's going to go briefly through what a recall is, but it's essentially exactly what you're asking about, pulling someone off the board, not because they did something wrong, but because you just don't want them on the board. Now, the thing to keep in mind about a recall is you can't actually pursue one for 60 days before or after any election. So there's 4 months out of the entire year that you can't touch a recall. You can start getting the ballots together during that 60 days, but you can't submit it during that time. So if you don't like who's on the board, either deal with it at the election or pursue that recall at least 60 days later. Or if they're actually doing something wrong, report that to the manager or the board and see if they actually get removed. Or if it's bad enough, report it to the police. The non-emergency line, by the way.
All right, perfect. Next question. I don't want to butcher your first name, so I'm going to say your last name, Mr. Stark. After the election, is the vote by the board for the president public or confidential?
I'm going to call you Tony because Tony Stark is a great character. After the election, the vote by the board for the officers is allowed to be a secret ballot. That's the only secret ballot that the board is allowed to use throughout the year. However, 99% of the elections I've attended have been, John, do you want to be president? Yeah. Okay, all in favor? Aye. Doesn't doesn't need to be done that way. But that is, you're allowed to do it as a secret ballot.
Okay, perfect. I'm gonna skip ahead because there's some people that already got questions, just to be fair. With only one level condo and 28 units, does any of the milestone inspection information apply to them?
No. So a one story habitable condo is not going to be subject to milestone inspection requirements or structural integrity reserve studies. And that's why I tried to clarify when I first started all this as to what the requirements are to even need to do that. It's 3 stories or greater. So anything that's under 3 stories, 1 or 2 stories, or some of the smaller buildings doesn't need to do that at all.
I'm going to mention before you do the last couple of questions, folks, now's a good time for the bio break. Get a drink, do what you got to do before Kirsten comes on and starts the second half. Back to you guys.
Talk, man, come on.
Okay, let me ask. So Bob asks, is the requirement to provide Zoom recordings of the meeting part of statute 913? And does that mean they apply to any meetings recorded as of January 1st, 2025, or any recorded prior apply as well?
So it is part of House Bill 913, which is now part of Chapter 718 of the Florida statutes, and it will apply from July, not January 1st of this year forward. So anything that was done before that, that requirement didn't exist, and they can't retroactively require you to do something that you had no obligation to do back then. But any meeting that's held virtually from July 1st of this year forward until hopefully that requirement gets revised somehow. And I am on a committee that is trying to change some of the statutes that kicked in previously and this year. And that's one of the ones that I'm going to be talking about with that task force. But as of right now, anything starting July 1st, 2025 is what you would have to have accessible on the website or accessible in the records.
Okay. There's some that are very specific, so I want to skip those and trying to get the general ones.
Okay,
Um,
good call. Because keep in
there-
mind, guys, when you're asking me or Kirsten questions, sorry to cut you off, Courtney.
no, good point.
When you're asking these questions, keep in mind if we're answering a very specific question, it's more likely that someone's going to figure out who you're talking about in your community, or that, the specific guidance is just something I can't give you because we're not sitting here with an attorney-client relationship, or I wouldn't give you that information because there's no privilege even if we are working together. And so it may be better to frankly skip some of those that are very specific, um, just to protect everyone involved.
I'm going to answer one that affects everybody. How long before we get today's certification? So after the course, we verify everybody has been attending in full with the Zoom spreadsheet. We cross-check that with the evaluation. We'll place that link into the chat at the end. So please press the chat button if you haven't already done so. It will say disabled. Don't worry, nothing to enable. We can still send stuff your way. And then we give us about between 5 and 7 business days to receive your certificate via email, and it will be sent to the email address you used when you registered for today's class. Okay. And also keep tabs on your spam folders, your junk folders, any alternative tabs. It will be coming from seminars@kbrlegal.com. Back to you.
All right, a few more. Alexander writes, I was told that unless you have Kaufman language, you cannot remove someone from the board for being delinquent in over 90 days in arrears. Is that true?
I mean, that's one interpretation that I've heard before, but I don't agree with at all. Kaufman language only impacts substantive changes to the statute. I would say this is a procedural change. And for those that don't know what the heck we're talking about, Kaufman language is that language in your declaration that says that it adopts the Florida Condominium Act as amended from time to time. The as amended from time to time language is like magic language in Florida condo law. And if you have that language, then any change to the Florida statutes will apply to your community. If you don't have that language, then there's at least the argument that any substantive change to the statutes doesn't apply to you. So my opinion is that is more procedural than substantive. If you owe 90 days worth, you are no longer eligible to serve. It's the same thing as all of these other criminal penalties that have been added where, if you haven't done this procedure, if you haven't taken a class, you're no longer eligible to serve for now. I don't see that as any different. It's all procedural in my opinion, although some judge somewhere may disagree. I've never seen a judge rule that way.
Okay. A few more. There's a lot about, so there's a few that are kind of similar. So I'm gonna kind of say them all at once, Alan.
Okay.
Hopefully you can decipher. So somebody asks, I have a question. Can a board chair step down and transfer the title to another one? Can a board, or yeah, so there's that one. Then there was, if a board member stops attending meetings and sends an email saying they don't want to be on the board, is that adequate to consider vacancy? And then I think there's one more. Hold on, they were kind of all over the place. So it's all about like leaving the board, getting off the
Yeah.
board.
So
Can a board have a resignation from a director, nominate people on the board without meeting duly posted? That one's a little not worded
okay, I
right.
think I know what that's asking, and I'll answer what I think the question is. So, can you drop off the board and nominate someone to replace you? You can nominate them, but the remaining directors get to decide. It's not just, I'm off and this guy's on. That's not the way it works. The remaining members of the board are going to get to vote at a board meeting with proper notice as to who replaces that person that dropped off. When it comes to the resignation, it has to actually say I resign. It doesn't have to use those words, but saying I don't want to do this anymore, or whatever the wording was, Courtney, that the question actually used, might not be enough. I would actually write back to the person and confirm, hey, we're sorry to hear this, just to confirm so that we don't replace you with someone else. If you were just upset and intended to stay on the board, are you officially resigning? And get the yes.
Yeah, so they did say if they sent an email saying they don't want to be on the board, is that
Yes,
considered?
that's what I'm saying. I don't think that's enough. I
Okay.
mean, there's a lot of things that I don't want to do as part of my position here at KBR. There's a lot of things for work. There's a lot of things for the Florida bar that I don't want to do. There's a lot of things for CAI that I don't want to do, but I'm still willing to do them. So until I say I'm not willing to do this anymore or I'm resigning from doing it, my perspective is that might not be enough to be a clear resignation. So I would just get, again, I would write back saying, I'm sorry you don't want to do this anymore. Are you saying that you're resigning from your position as an officer and director?
Yeah, and Carolyn asks a similar kind, they're not saying, this person's not saying they're resigning, but they're saying someone's on the board, they're not really doing anything or participating
Yeah.
in decisions.
And
Like
they're still on the board,
they're still on the
unfortunately.
board.
You'd have to have either a recall or questionable, but you could look at without giving specific guidance, you could bring chapter 617 of the Florida statutes to your attorney's attention and ask them that question. Because there is a provision that talks about removing people, but according to the Condo Act, it's really just a recall or that they're actually doing something wrong, not lack of participation.
Okay, great. We'll
And Jeff
answer.
mentioned one more, so I'll take one more. Courtney, you're responsible, and anyone that gets upset, sorry, it's Courtney's fault that I didn't answer the questions.
Okay. Oh my God, this is
No,
gonna
no, I'll
confuse
take
us.
I'll take the blame here. I got bigger
Pass
fish.
that
Okay.
one on, Jeff.
Um, Again, a lot of people are asking about, is this course required? If the board hasn't done it, how do they report it? Um, somebody said like none of the board members did the 4-hour class. What's the procedure? Who to report? Is this course required? How long does the board have to make sure all the members are certified? So I know you've answered this, but people are still asking, these are recent
Yeah.
questions. So that's like 3 questions in one.
Okay. Well, I mean, the bottom line is yes, every director has to take this course, at least every director of a condo or co-op. Um, you are automatically off the board if you haven't taken it, regardless of whether that's the entire board. not really a pretty situation that might require a receivership. So I would suggest that you bring it to either the manager's attention or one of the other directors' attention so that they can fix the problem. But yeah, I mean, everyone needs to take the course. You're suspended if you don't within the 90 days after the election result is announced or you're appointed to the board. I don't know how much clearer I can be other than to say you're off if you don't do that.
All right,
And
perfect.
it's not just taking the course, by the way, it's making sure that the certificate from the course is actually in the association records.
All right. I think that's good. I mean, we got
Okay.
a lot. There's only, I think, 9 left. So maybe Kirsten can help answer some of those.
Yeah.
So don't get too mad. There's still an opportunity for more questions, but Alan's time is done. Thank you so much,
Thank
Alan.
you.
In Winter Springs.
You got it.
I appreciate you and your time. You're a very dynamic presenter. You make it fun. You've had a couple jokes in there, and I was laughing with the camera off all along. So again, thank you so much.
All
Wait
right.
till he
Thank
covers
you.
annual budgeting in a future webinar. Hey, and I just want to mention too, when Kirsten takes over now, try to hold off on typing in your questions because a lot of the times, many of you jump the gun and you type in something that Kirsten's going to cover a little bit later on in the presentation. So do the best you can to hold off on typing in questions until a little bit later.
All right. Well, thank you all for having me. Thanks to GRS and Courtney in particular. And hope to see you at the next one. But if there are any questions, if there are questions about what I went through that Kirsten doesn't have time to answer, because let's be honest, hers is the more important and interesting stuff that is probably going to get a ton of questions. Feel free to reach out to me. My email address is right on the slides on the front, as is Kirsten's. And look forward to hearing from whoever wants to speak. Kirsten, all you, thank you again for your time and good luck.
Thanks,
Bye.
Alan.
Bye, everybody.
All right, let me try to share my screen. My least favorite part of presenting. Can you see anything?
Not yet. Give it a minute. Sorry. I was talking and then not talking. Hold on. I'm not seeing. Oh, now I'm seeing stuff. Okay. It's not in like presentation mode. I don't know if that
Yeah.
matters.
Let me put slideshow. See if that works. All right.
Yeah, perfect.
Does
I
that
see
work?
it. Yeah.
All right, very good. I think we are rock and rolling now. All right, so for those of you who came into the program a little bit later after I had gotten off, my name is Kerstin Henze, and I am one of the attorneys with the law firm. I manage the West Coast office for the firm, which is located in Tampa. And I'm going to cover topics 3 and 4. So in topics 3, we're going to discuss levying of fines, financial literacy, and transparency. So let's go straight to it. All right, transfer fees. Transfer fees are also referred to as application fees, and they have to do with sales and leases, or really any other type of transfer of title in a unit. So what the statute currently provides is if you have the ability, specifically the authority in your governing documents to approve or disapprove sales or leasing, and you have authority in your documents to charge for this transfer or application fee, then the association can do so. And presently, the statute provides that the fee cannot exceed $150 per applicant, other than husband and wife, or parent-dependent child, which are considered one applicant. Now, this $150 fee is subject to change, so it is adjusted by the division. Okay, but that's the rate at the moment. Again, you would really only be able to charge for this application fee if the authority is in your governing documents. And what this fee really is intended to cover is, the cost of undergoing a background check on the applicants, whether it's the prospective purchaser or it's whether it's a prospective purchaser or a prospective tenant. Now, in addition to charging an application fee, the association can also charge a security deposit. Okay, again, if authorized in the declaration or the bylaws, that is what the current statute provides. So, assuming you have the ability to approve and disapprove leasing, and you have the authority to charge a security deposit, then you can charge up to 1 month's rent, whatever the prevailing rate is in your area. The funds will be held in escrow, and then when the tenant vacates, if you're not making any claim on the security deposit, it will have to be refunded to the tenant in accordance with Chapter 83 of the Florida statute, which is the chapter that governs landlord-tenant transactions. Now, important to note that the security deposit is only intended to cover damage to the common elements or association property that's caused by the tenant or the tenant's family members, guests, or invitees. It is not intended to cover, for example, unpaid monetary obligations other than damage caused by the tenant. So, for example, if the owner is delinquent on any assessments owed to the association, whether it's regular or special assessments, or there's any outstanding attorney's fees or costs, or, for example, fines, if you've imposed fines against the owner for violations and those have not been paid, the security deposit cannot be applied to address those delinquencies. Okay. All right, let's move on to estoppel certificates. So this will come up when an owner sells their unit. If you recall, when you purchase your unit at the condominium, there's typically a title company involved. And one of the functions of the title company typically is to contact the property manager or the agent of the association to confirm, what if any assessments are outstanding on the unit, how much does the current owner owe, if anything, what needs to be essentially brought current on the date of closing. So when that title company sends that request to the association, that's typically referred to as an estoppel request. And so when you receive that estoppel request, the association has an obligation to respond by way of giving an estoppel certificate. Now, the association has 10 business days. So within 10 business days of receiving a written request for estoppel, the association has to respond. The association must designate on its website the person or entity with a street or email address for receiving the estoppel certificates. The estoppel certificate can also be completed either by a board member, an authorized agent, or authorized representative of the association, which can be, for example, your property manager, even your attorney. The estoppel certificate must be provided either by hand delivery, regular mail, or email, and it must be signed by an officer or authorized agent of the association. Now, in the next few slides, we've provided to you basically the content of the estoppel certificate. So these are essentially the questions that you would have to answer on the estoppel certificate. So the first part is, very general, basic information about the owner, the association, the requesting party. And then there's going to be a section in the estoppel certificate regarding assessments relative to the unit that is subject to the sale purchase, right? So the estoppel will ask you about the amount of regular periodic assessments, the date that these assessments are paid through, the date of the next installment. It'll ask you for an itemized list of all assessments, including special assessments that are owed. on the date of issuance of the certificate of estoppel. And then there is this other part in the estoppel certificate that is going to ask you these other more general questions. So, for example, if you're authorized to charge a transfer fee or an application fee, which we just discussed, you'll disclose that. Number two, I really want to kind of focus on this one for a minute. This question asks whether there are any open violations of any rules or regulations, okay, concerning the selling owner. So if there are open violations, let's say the owner undertook an unauthorized alteration. Let's say they enclosed their balcony, right? Put glass enclosure, which was not approved by the board. And this is presuming the board even has the ability to approve or disapprove these types of alterations. But let's say this owner did this alteration without board approval, and you have notified the owner of the violation, and you've made a demand on the owner to remove these glass enclosures. And again, this is also presuming that you are enforcing you have the ability to approve alterations and you're enforcing that covenant. And let's say the selling owner's just, continuing to ignore the association. Well, this would be the opportunity for you to disclose that open violation. By doing so, now the buyer is aware of the open violation. And when that sale closes, the new owner, the buyer, will have to resolve the violation if it's not addressed prior to closing. Okay. Now, what happens is if you do not disclose that open violation on the estoppel, then you run the risk of the association waiving the ability to then enforce that open violation against the buyer after closing. Okay. So if this violation is not disclosed and then you send a demand letter to the buyer after closing saying, hey, by the way, there's this open violation that was not addressed by the selling owner, you now have to address it. Well, if that buyer is savvy enough or retains an attorney that practices in this area of the law, then they could potentially raise the defense of waiver. You failed to disclose the violation, and now you've waived the ability to pursue this violation against the buyer. Okay, so just be aware of that. If you have the ability or the authority to approve or disapprove sales, this is the time that you would also disclose that in number 4. Okay. Now, the statute authorizes the association to charge for preparing these estoppel certificates. So the current rate that you can charge for preparing an estoppel certificate, if the owner is not delinquent to the association, that amount is $299. Now, if the owner is delinquent to the association, if the owner owes any money to the association, then you can charge an additional $179 for preparing the estoppel certificate. That's on top of the $299. If the estoppel request is being requested on an expedited basis, and provided you can respond within 3 business days, then you can charge an additional $119 fee. Now, if the association fails to deliver the estoppel certificate within 10 business days of receiving the request, the association cannot charge a fee. If there's a situation where the selling owner has multiple units and you've received estoppel requests for a number of units, then the statute provides a fee schedule of how much the association can charge in responding to these estoppel requests based on the number of units that are being sold. Okay, so for most, this will not apply. The fees, the estoppel fees are adjusted every 5 years based on the Consumer Price Index, and it's the Department of Business and Professional Regulations, the DBPR, that's charged with the adjusting of these fees. Now, the estoppel certificates, if they are delivered by hand delivery or by email, they are effective for 30 days. If the estoppel certificates are delivered by mail, then they are good for 35 days. Okay. Now, the association cannot charge for an amended estoppel certificate. So if you have to amend it, you cannot charge for making that revision. However, the association can charge for a new estoppel certificate, even if it's regarding the same transaction, if it is issued after the previous estoppel certificate expires. So what sometimes can happen is that the closing date, sometimes gets pushed, right? And so you were supposed to close on September 1st for whatever reason, it doesn't close, and the closing date is extended. And let's say you've already provided an estoppel certificate that's good for 30 or 35 days, and then the estoppel certificate expired, and now the closing date is pushed, and the title company has made a new request for an updated estoppel certificate. Well, in those circumstances, you can charge for a new estoppel fee. All right, other requested information. Associations or their authorized agents can also charge a reasonable fee to a prospective purchaser, a lien holder, the current parcel owner, or member for providing good faith responses to requests for information on behalf of a prospective purchaser or lien holder, so long as the fee does not exceed $150 plus reasonable cost of photocopying and any attorney's fees incurred by the association in providing a response. So sometimes you might be in a situation where if the buyer is trying to get a mortgage, the lien holder, the mortgage holder might send a questionnaire to the association, right? With a bunch of questions that the mortgage holder will need to assess in order to determine whether or not to provide a loan to the buyer, right? And so per the statute, the association can provide responses and can charge for doing that. And if you need an attorney to assist with the responses, you can charge for the attorney's fees. Now, the statute also says that the association and its authorized agents are not liable for providing information in good faith pursuant to a written request if you provide the following disclosure, which is that sentence in italics at the end of this page, which is the responses herein are made in good faith and to the best of my ability as to their accuracy. So make sure that any response includes this disclosure. Other purchase and sale documents will include what is known as a condominium question and answer sheet. This is a one-page document for those of you who are not familiar with. You can download this from the website of the Division of Condominium, and it essentially asks you several questions to which the association has to respond and update annually. Okay, questions include, for example, what are your use restrictions? There's a specific question about leasing at the condominium. How many votes are per unit? So forth and so on. And so you have to respond, and you have to annually update your responses if there's been any changes to the responses. And then you keep that question and answer sheet as part of your official records, which owners are entitled to inspect. And then for all residential sale transactions, it is a seller's duty to provide buyer with notice of all hidden defects. That's just something for the selling owner to know. All right, we're moving on to use right suspensions, voting suspensions, and fining. All right, so we're going to talk about fining and suspending of use rights for everything except the failure of an owner to pay their monetary obligations to the association. So if an owner or their guests, tenants, occupants, invitees, if they violate the governing documents or the association rules, the association has the ability to fine them, as well as suspend their use right to certain amenities, okay? And we'll talk a little bit in detail of what the process is, but essentially the authority to either fine or suspend use rights is something that is provided in the governing documents. You don't need specific authority to fine or suspend use rights in your governing documents, okay? It's already given to you in the statute. There was a question when Alan was, one of the questions that Alan answered had to do with Kaufman, right? Whether or not is a certain part of the statute applied to this particular community who doesn't have Kaufman. Well, this is one of those instances where finding and suspension of use rights is a procedural issue, not so much a substantive issue, right? And so regardless of whether or not you have Kaufman language in your documents, the fining and suspension provisions of the statute will apply to your community, okay? Now, the way I like to describe the process of fining and suspending use rights for violations is a two-step process, essentially, okay? And this is the statutory process. So regardless of what your documents provide, and some of the documents, might be outdated and might have, a different outdated procedure that no longer complies with the statute. But regardless of what your documents provide, this is the process that you need to follow to properly fine and suspend use rights to avoid a successful legal challenge. So the statute essentially sets out a two-step process, right? So the first part is that the board has to adopt the fine or the suspension of use rights. And then once the board adopts that, and presumably, prior to even the adoption of the fine or suspension of use rights, you would have already sent a number of violation letters, demand letters to the owner or the owner's tenants, invitees, letting them know, hey, you're in violation of this portion of the declaration or association rules, and you have X amount of time to comply. And if you don't comply, then you are subject to either being fined or your use rights will be suspended, right? So I'm presuming you've already kind of gone through that violation process, right? If the owner still hasn't complied, then this is the part where the board can then pursue the fine and suspension. So the first part again is the board adopts the fine or suspension of use rights at a duly noticed board meeting. Typically that just requires 48-hour post notice. Make sure, and we'll talk about this later on in the slides, make sure your notice has the date, time, and location of that board meeting, as well as the agenda item. Once you've adopted the fine or suspension, however, the statute says that the board, the fine or suspension cannot be imposed until the violating owner has gone before a committee. So there has to be a committee hearing, okay, which the owner is entitled to attend to dispute the fine or suspension. And you have to give notice to the violating owner of that committee hearing at least 14 days in advance. Okay, so you have to give them at least 14 days from the date you provide the notice for the owner to then make arrangements to attend this committee hearing. Okay, so that's the 14-day notice. Now the hearing has to be held before an impartial committee of at least 3 individuals. Okay, the role of the committee is simply limited to determining whether to confirm or reject the fine or the use right suspension. So they're not there to negotiate the fine, to reduce the fine or increase the fine that has been adopted by the board, no negotiate the suspension. Their sole job is to either confirm, to ratify the fine or suspension imposed by the board, or to reject it. And if the committee does not confirm the fine or suspension, it cannot be imposed. Now, the impartial committee has to consist of at least 3 members who are not officers, directors, or employees of the association, or the spouse, parent, child, or sibling of an officer, director, or employee. The fine also cannot exceed $100 per violation and may be levied on the basis of each day of continuing violation with a single notice and opportunity of hearing, but cannot exceed 1,000 in the aggregate. So let's take the example of a condominium that has a no pet restriction, right? You're not allowed to have pets. It's come to your attention that this one owner has a pet. And presuming that you have enforced this no pet policy against all owners uniformly, you've sent now a letter to the owner saying, hey, it's come to our attention you have a pet, you're not allowed to have pets, please remove the pet from the building. And let's say you give them 10 days to remove the pet, okay? For each day that that pet remains in the unit, you can charge $100 up to a maximum of $1,000 for that particular pet violation. Okay. Now, let's say you've gone through this whole process. The board has adopted the $1,000 fine. The committee has had their hearing and has confirmed the fine adopted by the board. The statute currently provides that that fine cannot become a lien against the unit, and it is due 5 days after the date of the committee meeting at which the fine was approved. So if the committee confirms the fine, then you'll send a written notice to the owner letting them know the fine has not been imposed, and then provide them the date by which the fine has to be paid. If the owner does not voluntarily pay the fine, again, the statute says it cannot be recovered as a lien. So you cannot pursue collection foreclosure against the owner to recover this lien. So practically speaking, what that means is that you can pursue the fine through small claims court, but the reality is that it costs $500 to file a complaint in small claims court, right? That's not even including attorney's fees to even prepare the complaint. So more likely than not, boards will not pursue collection of this fine through small claims court, right? And so what will happen is the fine will just remain on the account ledger. And hopefully when the unit eventually sells, you will disclose this unpaid fine on the estoppel certificate, right, that we just talked about a few slides ago. And then it'll get paid at closing, okay? All right, use right suspensions. So now we're going to talk about suspension of use rights. Suspension of use rights for violations, you're going to go through the same process as I described for the fining. So the board will adopt the suspension of use rights, and then there has to be a committee hearing that at which the committee will either ratify or reject the suspension. Now, if you're going to suspend use rights for the failure of the owner to pay his or her monetary obligation to the association, that can be done at a board meeting. So you do not need to have a committee hearing if you're going to suspend use rights because the owner is delinquent. Okay, if the owner's more than 90 days delinquent on any monetary obligation due to the association, and that can include regular special assessments, costs, attorney's fees, even a fine. So if you had imposed a fine and the fine remains unpaid, that is an unpaid monetary obligation due to the association. Now that can serve as a basis for you to suspend the rights of the owner to use certain facilities, amenities in your condominium. In order for the use right suspension to take effect, the board must notice the owner, tenant, occupant, licensee, or invitee of the suspension after it's been approved by the board. And the use right suspension is effective until the monetary obligation is paid in full. So once that delinquency is brought current, then the use rights basically are automatically reinstated. Now, let's talk about, what types of facilities or amenities you can suspend use rights to. This will apply primarily to your common facilities, right? So your pool, your clubhouse, your tennis courts, your gym, and you might have other amenities. But essentially, you know, if you have the ability to control access to these facilities, for example, through some kind of card fob system, then yes, you can suspend use rights, and this could be a viable option to enforce payment, right? Now, the statute does say that the suspension, however, does not apply to certain areas. It does not apply to limited common elements intended to be used only by that unit. So, for example, if balcony is a limited common element to a unit, according to your governing documents, well, you can't suspend the right of an owner to go on their balcony, right? You also cannot suspend use of common elements needed to access the unit. So you cannot suspend the right of the owner to, you know, walk in the hallway, for example. You can't suspend utility services, and you cannot suspend the ability of the owner to use their parking space or to use an elevator. Okay. Now, another remedy that you have is the suspension of voting rights. And this will apply if the owner is delinquent to the association for more than 90 days. With a caveat, which is the first blue bullet point, the delinquency also has to be greater than $1,000, and proof of the obligation must also have been provided to the owner 30 days before the suspension takes effect. So owner has to be delinquent for more than 90 days. The amount of the delinquency has to be over $1,000, and you needed to have notified the owner of this delinquency at least 30 days before you suspend the voting rights. Suspension of voting rights is also something that the board can do at a board meeting. You do not need a committee hearing for suspension of voting rights. Now, there is a small caveat here at the bottom of this slide. I mentioned that, you know, suspension of use rights and fining is something that the board can do without having this authority specifically in the declaration. Well, with regards to suspension of voting rights, a case came out in 2020, which provides that essentially, in order to suspend voting rights, you need to have specific language in your declaration authorizing you to suspend voting rights, or you need to have Kaufman language. So this court, I guess, you know, took the position that suspension of voting rights is more of a substantive issue as opposed to a procedural issue. And this was the ruling, essentially, from this court. So in an abundance of caution, until this issue is further clarified in the state of Florida, if you want to suspend voting rights, it might be prudent for you to amend your declaration to either expressly give you the authority to suspend voting rights, or you'll need to have Kaufman language to authorize you to suspend voting rights. Now, for many associations, suspending voting rights is a useful tool, especially if you're looking to propose amendments to the membership for their approval. So if voting rights have been suspended properly, the voting interest allocated to a unit cannot be counted towards the total number of voting interests for any purpose, including the number necessary to establish quorum and the number that's required to approve the action. So what that means is, let's take the example of a condominium with 100 units. And let's say you're trying to get certain amendments approved, some controversial amendments approved, right? So if you've suspended the voting rights, let's say of 10 owners, right? Well, and let's say, further assume that quorum in your community is a majority. So that's 50% plus one of the 100. Well, if you have reduced the, if you've suspended the voting rights of 10 owners, well, now for quorum purposes, quorum is going to be a majority of the 90, not a majority of the 100 units. And let's say that in order to get these amendments passed, you need a vote of 2/3 of the membership. Well, again, the vote that you'll need would be, if you've suspended voting rights, would be 2/3 of the 90, not 2/3 of the 100. Okay. So many communities find suspension of voting rights beneficial for this reason. All right, let's shift gears. We're going to talk about budgets, reserves, and financial reporting. Now, Alan covered the structural integrity reserve, right? Because that was a connection with the milestone. So I will not be talking about those reserves. I will be talking about the non-SERS reserves, your basic, your traditional reserves. Okay, so budgets, the board has to prepare an annual budget every year, which must include estimated revenues, operating costs, and reserves for the upcoming fiscal year, as well as the beginning and ending periods of the fiscal year, and total assessments for each unit type. This is what the statute says has to be included in your budget. And I will tell you that over the years, I've had to deal with division complaints, owners who file complaints with the division on budgetary issues. And I will tell you that the division does take very seriously budgets, and they do scrutinize budgets to make sure that it complies with the letter of the law. So not having, for example, the beginning and ending period of the fiscal year could be found to be a violation if a complaint is filed. All right, so at a minimum, your budget might include some of these line items. These are just your average, your typical line items that you might find in a condo budget. Of course, you might have substantially more than this, but essentially you'll have a line item for administration, management fees if you're managed by a management company, certainly all your maintenance and repairs, taxes, your professional expenses. So for example, if you have legal counsel or you've had to retain an engineer, you would put that in this line item. You might have other expenses, and then we'll talk about reserves. Now, in terms of adopting the budget, the budget must be adopted at a duly noticed board meeting, and the board must provide at least 14 days written notice, either hand delivery by mail or electronic transmission to those owners who have consented to receiving notices electronically. And then that notice also has to include a copy of the proposed budget. So you're going to be providing the notice of the meeting at which you're going to adopt the budget along with a copy of the proposed budget. Now, the person that's providing the notice of the meeting also has to execute an affidavit, which basically confirms that you have complied with this 14-day notice requirement. And then please note that if the board makes a change to the budget during the properly noticed board meeting, it does not need to resend or renotice the budget meeting. So your proposed budget is exactly what it is. It's proposed, it's an estimate, right? And let's say at the board meeting, so you know, there's been some new developments, so some numbers might change. That's okay. You can still adopt the budget without having to renotice the meeting or resend a copy of the budget to everybody. Now, this is a new statutory requirement. This was in House Bill 913 that took effect July 1st, just several months ago. So what this refers to is adoption of a budget by the board in which assessments are increased by more than 15% from last year's budget. Okay. So it used to be, this was in the statute, that if the board adopted a budget and increased assessments, you know, by 115% from last year, so 15% increase, Then there was a mechanism for the members to essentially propose an alternate budget, right? And then approve the budget, and that's the budget that would go into effect. That's what the statute used to say. That whole process system has now been, redrafted, and what the statute currently provides is, well, first, of note is that the budget meeting can be conducted in person as well as via video conference. Okay, and we'll talk about video conferencing a little bit more, but essentially, yes, you can have a budget meeting via Zoom. Now, if the board proposes in a fiscal year an annual budget which requires assessments against owners which exceed 150% of assessments from the preceding year, the board has to simultaneously propose at the budget meeting before adoption of the annual budget a substitute budget that does not include any discretionary expenditures that are not required to be in the budget. Okay, so in other words, when you're proposing a budget, if the new budget increases assessments by more than 15%, you have to simultaneously already have a substitute budget that you're gonna have to also present to the members for their consideration. And then the substitute budget cannot include any discretionary expenditures. Now, of course, the statute doesn't identify what or define what discretionary expenditures are. I'm also not aware of any association that these days has any discretionary expenditures. So, be that as it may, this is what the statute currently provides. Now, in determining whether the budget exceeds 115% from last year's budget, the following items are excluded from this calculation. So you're not going to include reserves for repair or replacement of condominium property. These would be your non-SERS reserves. You're also not going to factor in your SERS. And you're not going to factor in your insurance premiums. Okay, so these line items, you're not going to calculate for purposes of determining the 115%. Now, unit owners must consider and may adopt the substitute budget prior to the board's adoption of the budget that exceeds 115% threshold. An adoption of the substitute budget requires the affirmative approval of the majority of all the voting interests unless a higher percentage is required by the bylaws. If the substitute budget is not adopted by the membership, then the annual budget previously proposed by the board may be adopted. And then at least 14 days before the budget meeting in which the substitute budget will be proposed, the board must hand deliver or mail to each owner notice of the meeting. So essentially, you're going to have your board meeting, which will be noticed 14 days in advance, at which you're going to submit your proposed budget as well as your substitute budget, if it applies. And then what the statute doesn't specifically address, but what you need to consider practically is, remember, this is happening at a budget meeting, right? The budget meeting is a meeting at which the board adopts the budget. But if you are proposing a substitute budget, which is a budget that needs to be considered by the membership, then there has to be a membership meeting associated with that. So practically speaking, what you're going to be doing is, at the budget meeting, you're going to be essentially recessing that meeting. You're not adjourning, you're just recessing the meeting. And then you're going to have to call a membership meeting, okay, for the membership to consider this substitute budget. And then at that membership meeting, the membership will either, adopt or reject the fine. And then once that membership meeting is adjourned, then you're going to reconvene your budget meeting. Okay, and that's the meeting at which you're going to eventually adopt the budget if the substitute budget was not adopted by the owner. So a little bit of a logistical a challenge there. So definitely encourage you to discuss this with your legal counsel if you are going to be in this position. All right. Do note that effective July 1st of 2021, this was a change that went into effect in 2021. The board is required to adopt the annual budget at least 14 days prior to the start of the association's fiscal year. Okay, so if your fiscal year is a calendar year, 14 days before that December 31st deadline, you have to adopt the budget. Now, the statute does say that in the event the board fails to timely adopt the budget a second time, it is deemed a minor violation and the prior year's budget continues in effect. All right, reserve items. I've provided here some definitions of what how capital expenditures, deferred maintenance are defined in the admin code, Florida Administrative Code. And then I've given you some examples of reserve items for capital expenditures, deferred maintenance that are not, most of these are not CEUs. So I know roof replacement and building painting is, but other examples could be your seawall replacement or air conditioning replacement, sidewalk improvements, and you might have others. But before the CEUs portion of the statute went into effect, the statute had a requirement for condominium budgets to include reserves for the following items, right? Which is your roof replacement, your building painting, your pavement resurfacing, and then any other item that has a deferred maintenance or expense or a deferred maintenance or replacement cost that exceeds, and this was a change that just took effect July 1st, $25,000 or the inflation adjusted amount determined by the division, whichever is greater. So, you know, let's go back for a minute. Roof replacement and building painting, they have since been added to your CEUs. But if you have, you know, parking areas and streets that you own and it's your obligation to pave, then pavement resurfacing is going to be part of your statutory non-CEUs reserves, as well as any other item that might have a deferred maintenance expense or replacement cost that will exceed $25,000. So this used to have a $10,000 threshold, but now the statute has basically adjusted that $10,000, which is the equivalent of basically $25,000 nowadays. And so these statutory requirements have not gone away. So for example, seawall replacement. Seawall replacement is if you have a seawall, it is not a specific item under the CEUs requirement, right? Unless your engineer determines that, you know, the seawall should be part of the CEUs, right? If not, seawall repairs will likely fall under your non-statutory reserves. Now, do know that the division must annually adjust for inflation, this $25,000 threshold, which is going to be based on the Consumer Price Index. In terms of computing your reserves, you should have a reserve study done, just like you have one for your CEUs, right? You'll have a professional come and evaluate your reserve items and then essentially provide you with a spreadsheet of what the remaining useful life is on these reserve items, as well as the estimated cost to replace these items at the end of their useful life, right? So here at the bottom of the slide, this is what your reserve schedule needs to include. These are the different columns. And hopefully you have an accountant that assists you with preparing your budget or your reserves. So, so your reserve schedule should be in compliance with this. All right, waiving or reducing reserves. As Alan mentioned, you're no longer allowed to waive or reduce CEUs reserve funding. Okay, so these slides, the next few slides, only apply to your non-statutory reserves. With House Bill 913, which was signed into law July 1st, subject to owner approval and other procedural requirements, which Ellen discussed, funding of structural reserves could be temporarily paused for up to 2 years. Okay, so only under limited circumstances. Other than that, everybody else, unless you qualify for this pause, everybody should be fully funding their SERVs going forward. Now, for non-statutory reserves, for non-SERVs reserve, the board must adopt the budget with fully funded reserves unless your reserves are waived or reduced by the approval of a majority of the voting interest. So several years ago, if the board gave owners the option to waive the funding, full funding, or to reduce the funding of reserves, they were allowed to approve that by vote of the majority of the voting interest present at a meeting, so majority of quorum. That threshold has since been increased, so now you need a vote of the majority of your entire voting interest in order to waive or only partially fund statutory reserves. And if the vote to waive, the vote to waive or reduce reserves is only applicable for the budget year the vote was taken. So it's not a one-time vote for, in perpetuity. Every year, every time you adopt the budget, you have to adopt a budget with fully funded non-SERVs reserves, unless you give owners the option in that year to waive or reduce the reserve funding. Okay, so it is an annual vote that you have to take. Now, do note that whether or not you as a board, whether or not you want to give owners the option to waive or partially fund the non-SERVs reserves, that is completely within the discretion of the board. Because remember, your fundamental obligation is to fully fund. It is up to you whether or not you want to give owners the option to waive those non-SERVs reserves or partially fund them. If at the meeting no waiver or reduction in reserves is achieved, or there's no quorum attained, then reserves as fully funded go into effect. In terms of using your reserves, reserve funds and any interest accruing on those reserves, they have to remain in the reserve account and can only be spent for the purpose for which they were designated, right? So if you have a reserve, if you've established a reserve account for paving resurfacing, those funds can only be used for paving resurfacing. You cannot use them towards your seawall repair, unless the statute says the alternate use has been approved by a majority of the voting interest. So if you need to use your non-SERVs reserves for purposes other than for which they were intended, and presuming this is a bona fide association purpose, you need to get membership vote before you use those funds. And again, as a reminder, which Alan already mentioned, you cannot use SERVs reserves for alternate purposes. Okay. In terms of pooling, as Alan mentioned, you can pool your non-SERVs reserves. You are also allowed to pool your SERVs reserves. You just can't pool them together, right? And as Alan also mentioned, one of the new changes that went into effect is that it clarifies that you do not need membership approval to either go from a straight line accounting method for reserves to pooled method or vice versa. If you are going to give owners the option to waive or partially fund your statutory non-SERVs reserves, or if you're going to present a vote to the owners to approve the use of specific reserves for alternate purposes, then the statute says that your limited proxy and your ballot has to include this disclosure in the boldface, okay? So your limited proxy and ballot has to include this. And basically it says waiving of reserves in whole or in part, or allowing alternative uses of existing reserves may result in a unit owner liability for payment of unanticipated special assessments regarding those items. So you're essentially saying to the owners, hey, well, we're giving you the option to waive or partially fund these reserves or use reserves for alternate purposes. Just be aware that you could be subject to then a special assessment if we need additional funds. Okay. Switching gear to financial report. This was another area of the statute that was amended effective July 1st. So financial report refers to your end of year financial statement, right? And what the statute provides is that within 90 days after the end of your fiscal year or annually on the date provided in the bylaws, you, the association, have to have a end of year financial report prepared. And most associations will have an accountant, a CPA, to prepare this end of the year financial report. This is different from the monthly financial statements or reports that management might provide to you and that you report to the membership. Okay, this is the end of year financial statement. Then the statute says that within 21 days after that financial report has been completed, but, and this is the part that was changed in the statute, no later than 180 days after the end of your fiscal year, the association has to mail or hand deliver to each owner a copy of the most recent financial report. Or in the alternative, so you can either, within 180 days after the end of your fiscal year, you either have to give a copy of that financial report, or you're allowed to give your membership written notice, letting them know that the financial report has been prepared and will be provided to the owners free of charge within 5 business days upon receipt of the owner's written request. Okay. The old statute used to only give associations a maximum of 120 days from the end of fiscal year to provide this report. And many associations just couldn't comply with this time frame. As a practical tip, I would please, I would not recommend that you wait until the end of your fiscal year to then start looking for an accountant or to then retain an accountant to prepare this end of the year financial report. Okay, do your homework, your due diligence, engage your accountant well in advance of the end of your fiscal year, because eventually you're going to have to provide your accountant all this documentation, all these financials, right? And then it still takes some time for the accountant to prepare your end of year financial report, especially if you have to do an audit. So kind of, get ahead of the game, start early, start planning early for preparation of your financial report. Now, the level of financial reporting is going to depend on the association's annual revenue. Okay. So the statute provides a certain dollar threshold, and depending on where you fall within these dollar thresholds, you have a specific financial report that your accountant has to prepare. So for example, if your total annual revenue is $150,000 or more, but less than $300,000, then all you have to do is prepare a compiled financial statement. If your association has a total annual revenue of $500,000 or more, then by statute, you have to prepare a financial audit. Now, if your bylaws require you to do an annual audit, regardless of what your revenue is, then you're going to have to do your audit. Okay. So if you don't want to, if your annual revenue does not fall within number 3, and by statute, you're not technically required to do a financial audit, but your bylaws still require you to do an audit and you don't want to do it, then you're going to have to amend your bylaws to remove that requirement so that you would only be required to do a financial report in accordance with with what the statute provides. Okay. Now, the statute also says that members can vote for a reduced financial report. So you can present the option to the owners to reduce the level of financial reporting. So if by statute you're required to do an audit and you want to do something less than an audit, you're going to have to present that issue to the owners for their approval. And presuming that the owners approve a lower level of financial report, the statute now says that you cannot reduce the level of financial reporting for consecutive fiscal years. Okay, so if you do it this year, you cannot reduce your level of financial reporting next year. All right, that was it for budgets and financial reports and reserves. And now we're moving on to our final topic, where we're going to cover notice and meeting requirements, insurance requirements, and then conflicts of interest. So let me look at the time. All right, so we're about 1 hour. We have about an hour left, so I think we're good for time. All right, we're going to start with membership meetings. Okay. So with membership meetings, you'll see there's two headings here: annual members meeting and then special membership meeting. So there are two types of meetings. So under the big umbrella, so you'll have board meetings, you'll have membership meetings, and then under the membership meetings, you'll have two meetings. Your annual meeting is, if nothing else, it's the one meeting that you will have, during the entire year. And it is the meeting at which you're going to have your election. That is your annual meeting. Any other meeting that you might have throughout the year will be called a special membership meeting. Okay, so that's what that refers. So with regards to annual meetings, the statute says that the annual meeting of unit owners has to be held at the location provided in the bylaws. And if the bylaws are silent, the meeting has to be held within 15 miles of the condominium property. This used to say 45 miles, but now it says 15 miles, which is one of the changes that took effect July 1st. Now, the method of calling a meeting, the bylaws have to provide the method for calling the meetings, including annual meetings. And as I mentioned, your election has to occur on the date of your annual meeting. Now, special membership meetings refer to any meeting other than your annual meeting. When called by the board or upon written request of at least 10% of the unit owners, you'll have to call the special membership meeting unless, of course, you have different requirements in your bylaws. Okay, so yes, the board can call a special membership meeting. For example, if you're looking to get amendments passed, or if you wanted to reduce the level of financial reporting, any issue that requires a membership vote, the board can call a special membership meeting. Now, video conferencing. The statute was changed, took effect July 1st, which now defines what video conference is. And it basically means a real-time audio and video-based meeting between two or more people in different locations using video-enabled and audio-enabled devices. So the statute essentially allows now boards to conduct any kind of association meeting via video conference. So that would be your board meetings, your membership meetings, and then any committee meetings. You can now conduct them by video conference. Now, there's a caveat. If you do conduct a meeting by video conference, so this would be your typical, your Zoom meeting, then the statute says that the notice of that meeting has to include a hyperlink and call-in conference telephone number for owners to attend the meeting. And you must also have a physical location where unit owners can attend the meeting in person. So for years since COVID, once Zoom became a thing, board members were just using Zoom for for all types of meetings without having a physical location. And, for years with, at least our firm, we've been recommending to boards that if you're going to have a Zoom option, you should still have a physical location. Well, guess what? Now the statute has clarified this issue and says you need to have a physical location if you're going to have a Zoom meeting. There is no if, ands, or buts. Okay. And you are also going to be required to now record all your Zoom meetings. That was another point that was really not addressed in the statute the last few years. Should we record? Are we required to record? Well, now the statute says you have to record these Zoom meetings. And these recordings now have to be posted on the website. Okay, so not only is it part of the official record, but for those condominiums that are required to have website, remember the current threshold is 150, but come January, it's, any condominium, any association that has 25 units or more. So if you're going to fall under that website requirement, you're going to have an obligation to post these recordings on your website. So you're going to really have to think about whether or not you want to give that Zoom option going forward. Another change to the statute affecting these video conferences. So if the annual meeting is conducted video conference, so if you're going to give an option to have for owners to attend this meeting via Zoom, a quorum of the members of the board must be physically present at the physical location where unit owners may attend the meeting in person. If the meeting is conducted via video conference, it must be recorded and the recording must be maintained as an official record. So, a few things about this provision. As Alan mentioned, there is no present membership quorum requirement in order to conduct an election at the annual meeting, right? There is a membership quorum requirement to conduct other agenda items that you've set for your meeting, for your annual meeting, but not for the election. And so, unclear why the legislature has inserted this requirement to have a quorum of the board members physically present at the physical location of a membership meeting. Right? I mean, typically the board will attend the annual meeting of the members, but now it's a requirement. The statute also doesn't address what happens if a quorum of the board is not present. I would take the position that if a quorum of the board is not present, the association can still conduct the election part of the annual meeting, which only requires that 20% of the voting interest submit an election ballot to have an election. Okay, notices and agendas. Written notice of membership meeting must include an agenda and has to be mailed, hand-delivered, electronically transmitted to each owner at least 14 days before the membership meeting, as well as posted conspicuously on condominium property. The board must, by adopted rule, designate a specific location on the condominium or association property at which member meeting notices are posted. However, if there is no condominium property or association property upon which notices can be posted, this requirement does not apply. And then notices have to be mailed to each owner at the address last furnished to the association by the owner. The person providing the notice of the members' meeting has to sign an affidavit, basically attesting to having complied with the notice requirements. And then in lieu of or in addition to the physical posting of the meeting notice, the association may, by reasonable rule, also adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed circuit cable television system serving the association. So this would really only apply to those associations that currently have a bulk cable contract. If you don't have a bulk cable contract, essentially don't worry about it. This is just an alternative option. Associations may opt to deliver meeting notice by electronic transmission by following the following rules. So first of all, electronic notices can only be sent to owners who consent in writing to receiving official notices, right? So the owner's written consent must be signed by the owner or the person holding a power of attorney. The consent or revocation of consent may be delivered to the association also electronically or hand delivery or by mail. And then the owner bears the risk of ensuring delivery. If an owner has consented to receiving notices electronically, just note that electronic notice cannot be used for recall of a board member or notice of membership meeting at which a vote to forego retrofitting of a condominium with fire sprinkler system will be taken. And then notice of a meeting is effective when sent by the association, regardless when the notice is actually received by the owner. And the owner who consents to receiving notices electronically is solely responsible for removing or bypassing filters that block receipt of mass emails sent to the members. Now, the association is required to maintain the email and the email addresses and fax numbers for those owners who consent in writing to receiving notices electronically. And then do note that if consent to receive notice by electronic transmission is provided, those email addresses and fax numbers become accessible to owners. Okay, so if another owner in the condominium makes a request for inspection of records and specifically requests to know the email addresses of those owners, then those who actually consented to receiving notices electronically, their email addresses are accessible. Okay, so if you do not want your email address to be shared, then perhaps reconsider consenting to receiving notices electronically. The association cannot sell or share email addresses or fax numbers with outside third parties. And if this information is included in documents that are released to outside third parties, the association must redact the information before the document is provided. However, the statute does say that the association is not liable for inadvertent disclosure of any email address or fax numbers unless the disclosure was made with knowing or intentional disregard. In terms of website requirements, again, if you currently are under the website requirement, you do have an obligation to post notices of membership meetings at least 14 days prior to the meeting, as well as post any document that is associated with a membership meeting. So for example, if you have presented owners with an amendment to vote, that amendment also needs to be posted. If you do not currently, if you're not currently required to have a website, but you maintain a website, you can also still post notices on the website. All right, quorum requirement, unless you have a lower number in the bylaws, quorum for membership meetings is going to be a majority of the total voting interest. And then unless otherwise provided in the statute or in your governing documents, decisions to be made by members must be made by a majority of the voting interest represented at a meeting at which a quorum is present. So what this means is if you have a condominium building with 100 units, majority would be 50% plus 1, but majority of voting interest present at a meeting at which a quorum is present means the first thing you need to do is establish quorum. And assuming that quorum is 50% plus 1, presuming that's the minimum number of owners that show up at your meeting, 51 owners, then a majority of quorum would be majority of the 51 owners that are present at that meeting. What what could happen is, what will happen is that the more people, the more owners show up at the meeting, the higher that voting threshold will be, right? So if 60 people show up, then the vote that you would need is a majority of 60. If 75 people show up, a majority of 75. Okay, so that's what that means. Written consent. There is an option for owners to vote via the written consent process in lieu of having a membership meeting if your governing documents authorize this process. With the written consent process, essentially, you as a board, you'd be mailing like a memorandum or a letter to the owners expressing the action you want them to take. So, in the example of an amendment, you would be sending them a letter saying, hey, we've prepared this amendment. This is what we want you to consider. And then that letter would have essentially a consent, a line at the bottom of the form for owners to consent if they approve the amendment or the action. So only owners that consent to it would need to sign it and then return the form to the association, right? So owners who are against it, indifferent, don't care, you don't have to return the consent form. And then chapter 617 of the Florida statute, which is the chapter that governs not-for-profit corporations, which the association is, says that you have 90 days from the first executed consent form within which to get the necessary approvals that you need on a particular action. Okay, so it acts very similarly to a proxy. Member participation, owners do have the right to speak at membership meetings with regard to all agenda items. And the association may, and we recommend that you still adopt reasonable rules governing the frequency, duration, and manner of member statements. Now, members can also record and videotape a meeting subject to the rules adopted by the division. And we've provided basically the rules that are currently in the Florida Administrative Code. So voting by proxy, quickly, there are two types of proxies that you will have. There's general proxy and a limited proxy. Both are used for, can be used to establish quorum. General proxy is typically sent with a meeting at which, typically really like an annual meeting, if you don't have anything for owners to vote on other than election, but you still want to have the annual meeting to, for officers, directors to provide reports, state of the affair of the condominium, then you will likely send out a general proxy just to establish quorum. Okay, membership does not really vote via general proxy. Limited proxy is what the statute requires for owners to specifically cast a vote if they're not going to be present at a meeting. So limited proxies must be used, for example, to waive or reduce reserves, to waive financial reporting requirements, and certainly for any amendment to your governing documents and any other matter required under the Condominium Act. Unless the use of a limited proxy is required, general proxy may be used in voting for non-substantive changes to items for which a limited proxy is not required. So typically, if an owner is going to vote on anything, you will be using a limited proxy. The proxy, a limited or general, cannot be used to vote in an election or to vote to forgo retrofitting. And proxy given is effective only for the specific meeting for which it was originally given and any lawfully adjourned meeting. And a proxy is only good for 90 days after the date of the first meeting. And the proxy is also revocable at any time at the pleasure of the owner executing. All right, let's shift gears to board of directors. First, officers and directors have a fiduciary responsibility to unit owners and must act reasonably. It doesn't mean you have to be right, but you have to act reasonably in the best interest of the owners. Okay, not in the best interest of any one director, but of the membership. Directors cannot be compensated unless otherwise provided in the bylaws. Okay, so they do serve without compensation. This does not, this is for services performed by a director or officer in their director or officer capacity. This does not include services that a director might want to offer to the association that are not related to their position as a director. Okay, we'll talk about those types, that type of compensation and that type of conflict of interest later on. Unless otherwise provided, the corporate powers of a corporation not for profit are exercised by the board. Okay, so then that means that no board member, not even the president, should make unilateral decisions, right? So you should be functioning as a board and making decisions at duly noticed board meetings. Now, kickbacks are prohibited in the statute, and the statute defines what a kickback is. So an officer, director, manager may not solicit, offer to accept, or accept a kickback, which means it's defined in the statute as anything or service of value for which consideration has not been provided for an officer, director's, or manager's own benefit or that of his immediate family from any person providing or proposing to provide goods or services to the association. So, if an officer, director, or manager who knowingly solicits, offers to accept, or accepts a kickback, commits a felony in the 3rd degree, and is also subject to civil penalty and must be removed from office. There is no prohibition against officer, director, or manager from accepting services or items received in connection with trade fairs or education programs. Okay. There is also a new change that association and its officers, directors, employees, and agents may not use a debit card used in the name of the association or billed directly to the association. However, a person who uses a debit card issued in the name of the association or billed directly to the association for any expense that is not a lawful obligation of the association commits theft and must be removed from office. A director or officer charged by information or indictment with any of the following crimes must be removed from office. They include forgery of a ballot envelope or voting certificate used in a condominium association election, certainly theft, embezzlement of association funds, destruction or refusal to allow inspection or copying of an official record which is accessible to unit owners in furtherance of a crime. Okay. Obstruction of justice, and then any criminal violation under the Condominium Act. The board then must fill the vacancy only until the end of the suspension period or end of the director's officer's term, whichever occurs first. And if the charges are resolved without a finding of guilt, then the director or officer must be reinstated for the remainder of his or her term. A director or officer who has such charges pending may not be appointed or elected to a position as a director or officer of any association and may not have access to the official record. So, 6 ways to get off the board, essentially. You resign in writing, and you specifically indicate that you're resigning not just as from a specific officer position, but as a director from the board. Through the recall process, you can get off the board. If you are delinquent in the payment of any monetary obligation due to the association for more than 90 days. If there are criminal charges involving theft or embezzlement of funds, for knowing and willful violation of the Condominium Act, as well as failure to satisfy your certification requirement. And remember, that only means you're suspended temporarily until you comply with your certification requirements. You're not removed from office. All right, board meetings. In a residential condominium association with more than 10 units, the board is required to meet at least once each quarter. This change went into effect a couple of years ago now. So it's no longer okay that you just have all your meetings at the beginning of the year and then none towards the end. You have to have a meeting at least once each quarter. And then at least 4 times each year, the meeting agenda must include an opportunity for members to ask questions. Okay, so you have to designate on the agenda, you know, an agenda item that allows owners essentially to ask questions. Now, the statute doesn't say this has to be once each quarter, it just says 4 times each year. At times, the board may take action outside of the context of a properly noticed board meeting. And if that happens, typically in an emergency situation, then make sure that you ratify the decision or the action of the board taking outside of a duly noticed board meeting. And you do so at the next properly noticed meeting. Now, the statute does allow board members to use email as means of communication. Just do know that you're not allowed to vote by email. Typically, unless your documents provide otherwise, notice of a board meeting simply needs to be posted conspicuously on condominium property at least 48 hours prior to the meeting. Now, the statute does say that there are 2 types of meetings that will require 14-day notice, unless, of course, your documents provide for a greater notice requirement. But written notice of a board meeting at which a non-emergency special assessment will be adopted, or if you're going to consider an amendment to rules regarding unit use, not common element use, unit use, then notice of that board meeting has to be either mailed, delivered, or electronically transmitted to owners, as well as posted on condominium property at least 14 days prior to the meeting. And then you will also have to attest to compliance with these notice requirements by affidavit. The statute, again, does provide in different sections, specifically to board meetings, that yes, you can conduct board meetings via video conference, so your Zoom meeting. You just need to make sure that the notice of that meeting includes a hyperlink, as well as a conference telephone number for owners to call in, and that you also include the physical location of that meeting. And then the meeting has to be recorded, which then becomes part of the official records. The board must, by rule, also designate a specific location in condominium property where meeting notices will be posted. And for those who have a bulk cable contract and you have a closed circuit cable television system, you also have the option to post your notices and broadcast that notice on your cable television system. Website requirements, again, for those that currently fall into the website requirement, you also have to post notice of your board meetings on your website, as well as any document that is associated with that board vote, right? So if you're considering a contract, make sure that contract is also posted on the website. Board meeting notices, as with membership meetings, must specifically identify all agenda items. Now, an item not included on the notice may be taken up on an emergency basis by a vote of at least a majority plus 1 of the board members. And then such emergency action must then be noticed and ratified at the next board meeting. So this will come up if you've provided notice of your upcoming board meeting with a bunch of agenda items. You wanted to add one more. It was too late for notice. If you get a vote of the majority plus one of the directors at that meeting, you can consider this additional agenda items. Just make sure that you ratify that action taken at that board meeting as to that agenda item at your next board meeting. Be aware that if 20% of the voting interest petition the board to address an item of business, the board within 60 days of receiving that petition have to place the item on the agenda at their next regular board meeting. One of the changes that took effect also a couple years ago is that if the agenda relates to approving a contract for goods or services, then a copy of the contract has to be provided with the notice. Okay, and for some reason, there's a lot of confusion whether, what you might call a proposal or a bid is considered a contract. Sometimes, the vendor might just provide, one-page proposal, right, for services. If you sign that proposal, right, it becomes a binding contract. So essentially, if you are going to be approving service or the purchase of certain goods, in writing, then it becomes a contract. And so make sure that you provide notice of the meeting with the contract. Notice of a meeting at which you're going to be adopting a special assessment against owners must also specifically state that the assessment will be considered. You has to include the estimated cost and then the description and purpose of that assessment. Meetings of the board at which a quorum of the board is present must be open to all owners with the exception of two types of meetings. And those include meetings between the board and the association attorney with respect to proposed or pending litigation. And then meetings held for the purpose of discussing personnel matters. Just with membership meetings, owners may also tape record and videotape meetings of the board of directors, subject to the rules adopted by the division, which we've included them here on the slide. And you can read them at your leisure when you do get the slides. Now, an owner's right to attend board meetings includes the right to speak at meetings with reference to all designated agenda items, as well as on these other points, which was a change in the law that took effect July 1st of 2024, I believe. But essentially, they have the right to ask questions relating to reports on the status of construction or repair projects, status of revenues and expenditures during the current fiscal year, as well as on other issues affecting the condominium. However, the association may and really should still adopt reasonable rules governing the frequency, the duration, and manner of member statements. In terms of quorum, a majority of the board present at a board meeting constitutes a quorum. When a board member or committee member meet by telephone conference, those board members attending by telephone may be counted towards quorum. So before the statute even authorized attendance via video conference, the statute already authorized board members to attend not only via telephone, but they can appear by speakerphone and really any other video conference, any other platform, whether it's Zoom or Teams meeting or whatever else is out there, as long as a speaker is used so that everyone can hear the board member, and their attendance electronically essentially counts towards quorum. And unless otherwise provided in the statute or in your governing documents, the action of a majority of the directors present at a meeting at which a quorum has been attained constitutes board action. Also, directors cannot vote by proxy or by secret ballot at board meetings, except officers may be elected by secret ballot. A director who is present at a board meeting at which action on any corporate matter is taken is presumed to have assented to the action taken unless he or she votes against the action. In terms of committee meetings, a meeting of a committee to take final action on behalf of the board or to make a recommendation to the board regarding association budget are always subject to notice requirements and cannot be exempted. So these two types of committee meetings always require to be duly noticed. Now, if it's a meeting of a committee that is not for purposes of taking final action on behalf of the board, or one that will not be making recommendations to the board regarding the budget, they can be exempted from these board meeting notice requirements only if they're exempted by an amendment to the bylaws. So if they're not exempted by an amendment to the bylaws, and I've seen this in maybe one set of governing documents in the 15 years that I've been practicing in this area of the law, then what that means is that all committee meetings will have to be noticed as you would with a board meeting. Okay. All right, so let's do quickly insurance, and then the only other topic left after that is conflicts of interest. So we have about 30 minutes left, so we're good in time. A unit owner controlled residential condo association must use its best efforts to obtain and maintain adequate insurance to protect the association property, the common elements, and condominium property. And adequate insurance, regardless of any requirement in the declaration, may be based on the replacement cost of the property to be insured as determined by an independent insurance appraisal. So that replacement cost must be determined at least once every 36 months. The association should also have liability insurance for director and officers insurance, as well as flood insurance for common elements, association property and units, and certainly would be a requirement if you fall within a flood zone. Fidelity coverage is also a requirement in the statute. The association must maintain fidelity bonding for all persons who control or disperse funds for the association. And the term persons who control or disperse funds includes, but is not limited to, individuals that are authorized to sign checks, as well as the president, secretary, and treasurer of the association. The insurance policy or fidelity bond must cover the maximum funds that will be in custody of the association or its management agent at any one time. And then the cost of the fidelity bond is on the association. So big takeaway here is make sure that you contact your association insurance agent. Hopefully you've been in contact since we are in going into budget season. So you should have or should be contacting your agent to confirm, what coverage you currently have, what else you're required to have, and certainly might want to shop to see what else is out there if there is even some alternatives. Effective July 1st of 2024. If the division receives a complaint, the division will monitor an association for compliance with the statutory insurance requirements and can even issue fines and penalties established by the division for failure of the association to maintain the required insurance policies. In terms of what insurance, what you have, what what insurance you have to obtain. Every property insurance policy issued after January 1st of 2009 must provide the following coverage. You have to provide coverage for all portions of the condominium property as originally installed or replacement of like kind and quality, as well as all alterations and additions made to condominium property. Okay, the exclusions from the association coverages are the unit owner's responsibility to insure. So, second bullet point here, the association's coverage excludes all personal property within the unit limited common element, as well as floor, wall, ceiling coverings, electrical fixtures, appliances, cabinets, window treatments, and the replacement of these items. So these particular items and any insurance on these items is the responsibility of the unit owners. But just be aware that while the statute says that these items are the responsibility of the unit owners to insure, it doesn't require, the statute doesn't require owners to insure. So as of 2010, the ability to force place owner's insurance coverage requirement was eliminated. So not only are owners not required to maintain insurance for these items, you can't force place insurance. Owners are responsible also for the cost of reconstruction of any portion of the condominium property for which property insurance and the cost of any such reconstruction done by the association is chargeable to an owner and may be enforced and collected as any other assessment. So in the event of a casualty, and casualty is typically defined as an unforeseen event, right? So like hurricane, a sudden pipe break. So any portion of a condominium property that must be insured by the association, which is damaged by an insurable event, must be reconstructed, repaired, or replaced as necessary by the association as a common expense. The only things that the unit owners would be responsible for would be any portion of the condominium property for which the owner is required to carry property insurance, any portion of the property that is not paid by the insurance proceeds of the association if that damage is caused by the intentional conduct, the negligence, or failure to comply with governing documents, whether it's by the owner or the owner's occupants, tenants, invitees. And then the cost of any such reconstruction work undertaken by the association is chargeable to the owner and then enforced as an assessment. In the absence of an insurable event, so if we're talking about damage to the condominium or a unit that is not caused by an insurable event, then the association and owners are responsible for the repairs as determined by the maintenance provisions of the declaration. So it wouldn't fall under the insurance requirements of the statute, but rather you're going to have to look at your governing documents to determine who is responsible for what. Okay. And then let's quickly go through conflicts of interest, and then we are done. So just a few more slides. So directors, officers, and relatives of directors and officers, they have to disclose any activity that can be reasonably construed as a conflict of interest. And what is a conflict of interest? Well, the statute says that there is a presumption that there is a conflict of interest if these two things occur. So one, if it's a director, an officer, or a relative of these individuals, they enter into a contract with the association for goods or services. Or these individuals have an interest in an entity that is proposing to enter into a contract with the association. So a very typical example is if the board president owns a painting company, Joe's Painting, and the president would like his painting company to provide to do the painting of the building. Okay, there is a presumption that there's a conflict of interest in this case, which means that the statute doesn't necessarily prohibit. It would not prohibit the president from entering, or the president's company from entering into a contract with the association. But what the statute does provide is a procedure mechanism by which the board can approve that contract. Okay, so if a director, officer, or relative of these individuals propose to engage in any activity that's a conflict of interest, then that activity or that transaction has to be listed on the notice of the board meeting, as well as all contracts and documents related to this transaction or this activity. They have to be also included with your meeting notice, right? And then at that meeting, the approval of the contract requires a 2/3 vote of the other directors, of the non-interested directors. So the director or officer or relative who is interested in this transaction, they can attend the meeting. They can do a presentation. If it's the director or officer who has an interest in this transaction, their presence at that meeting will count towards quorum. But then the statute says that after the presentation, this director, officer, or relative, they must leave the meeting during the discussion and vote on by the board, right? And then 2/3 vote of the other directors are the ones that have to approve this proposed transaction. The director or officer who is a party or has an interest in this transaction will have to recuse himself or herself from the vote. And then if the board votes against the proposed activity, the director, officer, or relative must then notify the board in writing of his or her intent not to pursue the activity, or they have to withdraw from office. Then once the board has approved this transaction, this activity, then at the next regular or special meeting of the owners, you will have to disclose this transaction or this contract to the membership, and then upon a motion of the members, the contract may be canceled by a majority vote of the members who are present at that meeting. So while membership approval is not required to approve the transaction, the owners do have an opportunity to basically cancel that contract or transaction after the fact. If the membership votes to cancel that contract, then essentially the association can terminate that contract with the director or with that entity in which the director officer has an interest, and the association would not be liable for any termination fees or liquidated damages. They would only be responsible for the cost of the goods and services provided through the date of the termination. If the board finds that an officer or director has violated the conflict of interest provision, the officer or director is deemed removed from office and the vacancy filled according to law. Now, if the contract entered into between the director, officer, or relative and the association has not been properly disclosed, so if the association does enter into this transaction or contract without proper disclosure, that contract then becomes voidable and can be terminated upon a vote of 20% of the voting interest. And then if that contract is approved, then make sure that the contract is also posted on the website. Okay. And then quickly here, final slides, conflict of interest of managers, just a few more slides and then we're done. A community association manager or management firm, including directors, officers, or persons with any financial interest in the management firm or relatives of these individuals, they also have to disclose to the board any activity that may be construed as a conflict of interest. Well, the statute also provides what what constitutes a conflict of interest, and there is a presumption that there's a conflict of interest if these two items exist. So either the property manager or the management firm, including any director, officer, or person with financial interest in the management firm, or any relatives of these individuals, enters into a contract for goods or services or proposes to enter into a contract with the association for services other than management, or these individuals have an interest in another entity that is proposing to enter into a contract with the association. So as with conflicts of interest of contracts with individual directors or officers, the statute doesn't necessarily prohibit the association from entering into a contract that is subject of a conflict of interest. It provides, however, the mechanism for which a mechanism for you to approve those transactions. And it's substantially similar to to the slides that we just did for director conflict of interest. Essentially, you'll have to disclose the conflict of interest on the agenda of your board meeting at which you're going to be approving or considering this transaction. The disclosure has to be entered in the minutes. The transaction that's subject to the conflict of interest also has to be approved by a vote of 2/3 of the directors present. And then at the next membership meeting, you also have to disclose this contract or transaction to the members, and then they have the ability to terminate this contract. And if they do, then the association would not be liable for any liquidated damages or termination fees upon the contract terminating. If the board finds that the property manager or management firm or any director, officer, or persons with financial interest in the management firm or any other relatives has violated the section, then the association may cancel the management contract. Failing to disclose any conflict of interest also constitutes grounds for which disciplinary action may be taken against the management firm or property manager.